Good morning. Welcome to this year's Environmental Law and Policy Annual Review Conference, now webinar, or ELPAR as we call it. I'm Linda Bregan. I'm a senior attorney with the Environmental Law Institute and also a lecturer in law at Vanderbilt Law School. We are delighted to be here with you today, even though we certainly would prefer to be together in Washington. And I just want to say we particularly appreciate those loyal fans who return each year, and I want to say a special welcome to the Vanderbilt Law student alumni who are listening today. We're also very pleased again this year to welcome our co-sponsors for the conference, the DC Bar Environment, Energy, and Natural Resources Committee and the Women's Council on Energy and the Environment. So it has been 14 years, which is incredible, that Environmental Law Institute and Vanderbilt Law School have collaborated on this effort in which law students work to identify some of the most important ideas from the legal academic literature each year and bring them to policymakers and practitioners. We could not do this without the help of our stellar committee of public and private sector leaders, our advisory committee, and I think Heather has a slide just to show who those wonderful individuals are. They're also listed on our webpage. As you may know, the articles that we select each year to discuss at this conference are also published in shortened form with commentaries in the Environmental Law Reporter each August. And I want to just say a special thank you to the ELR team for making this all work. So particularly Jay Austin, Rachel Jean-Baptiste, and Bill Strobe. You're going to learn more about the process we use to select articles in just a minute from our wonderful third-year Vanderbilt Law students. But now I want to turn it over to Mike Vandenberg, who's actually here in the room with me, to talk about what we're trying to achieve with ELPAR. Mike is a chaired professor at Vanderbilt University Law School and director of the Climate Change Research Network. He's also my co-instructor for the ELPAR course at Vanderbilt and also a close family member. So I'm going to hand this over to Mike. Oh, sorry, just give me 1 second. There we go.
Great, close family member. I love that. Also known sometimes as husband. So let me just describe, if I may, for a moment, what we're trying to accomplish and welcome everyone on behalf of Vanderbilt University Law School. This is a wonderful collaboration with the Environmental Law Institute. We're really lucky to be able to do this. We're trying to do several very basic things here. The first is to provide an exceptional educational experience for our students, whether it is selecting articles from among the 300 to 500 published every year and arguing about which are the best policy ideas, to presenting programs like the one we have today, to organizing and managing what is effectively both a class and an organization. All those things, we hope, provide a truly exceptional educational experience, and that's really goal number one in many ways. The second is one that may be a little less obvious, and that is that we are trying to encourage academics not to just invent a can opener every time they need to open a can. And that's essentially the incentives that we all have in the academy. Stick with the theory, don't get bogged down in the feasibility of your ideas. And on some level, that makes a lot of sense. We want to all develop new theoretical approaches to problems. The challenge is that your theory can be very weak if you don't test your theory against the feasibility of different policy implications. So our goal here is to find those articles that take that very difficult step of examining and proposing feasible policy options. And we're doing it not just because we want to identify those options, but because we want to improve the quality of academic scholarship by forcing or inducing, encouraging academics to really wrestle with the hard questions that feasibility presents to theory, not just to feasibility itself. And then lastly, and the principal focus of today's event, is that we're hoping to move ideas from the academic world into the policy world. Linda and I both served in the Clinton administration. We both were following the legal literature at the time, and almost none of it was relevant to the kind of work we did day to day because it tended to be too dense, too many footnotes, really hard to move into quick thinking for people who are under lots of pressure to develop new ideas. So the idea here with our program is to help us produce a forum in which we can move ideas in a way that are easily digestible into the policy world. And we hope that's what will occur today. So back to you.
Back to Bruce.
Oh, Bruce, on to you, Bruce.
All right, thank you, Professor Vandenberg. Good morning and welcome, everyone. My name is Bruce Johnson, and I have the true honor of being the editor-in-chief of the 2021-2022 edition of the Environmental Law and Policy Annual Review, or as we like to affectionately call it, ELPAR. I want to quickly acknowledge the hard work of our 22 student members, as well as Professor Bregan, Vandenberg, and Heather Luedke, who have all become my good friends throughout this arduous but incredibly worthwhile process. We also owe a big thank you to our advisory committee, Vanderbilt Law School, and ELI for making this all possible. So now I'm going to go ahead and explain ELPAR's article selection process, which Jay will later get into in a little more detail, and how we have gotten to this exciting point that we're at today. So as the professors indicated, ELPAR seeks to publish the best environmental law and policy articles published each year, which are addressing pressing environmental issues. ELPAR is a joint publication by Vanderbilt Law School and the Environmental Law Institute. It is also a class here at Vanderbilt made up of 20 to 22 law students each year, 2L and 3L members who actually had to participate in a write-on competition to become members. Our selection process for articles follows a series of major steps. We begin by logging every article published in the Law Review of Schools ranked in the US News Top 100, as well as a variety of environmental law specific journals, looking for articles that use the word environment, usually around 500 articles per year. We then screen these articles down to about 150 to 200, which discuss the environment in a meaningful way and relevant within our context, not just like the political environment. After evaluating these articles based on our 4 major categories of persuasiveness, creativity, impact, and feasibility, 2 students each summarize the articles, which we will then discuss as a class with the guidance of professors Bregan and Vandenberg. Over the course of 2 semesters, the students and professors collectively settle on a top 20 list of the most exciting and innovative environmental law and policy articles, which we'd like to highlight in our ELPAR August edition. With our top 20 selected, we then consult our expert advisory committee in reaching a top 3 to 5, which is published in a condensed version in the August edition of ELR. We also list the top 20 in that edition, each with a big idea sentence that explains the crux of the article and its policy proposal. This year, we evaluated 172 articles and selected 4 to include in our publication, 3 of which will be highlighted in today's conference. Hope you guys enjoy. Let's pass it off to Jay now to get into some of the numbers.
Good morning. My name is Jae Kim, and I'm a 3rd-year law student at Vanderbilt Law School, and I've had the honor of serving as the development editor of ELPAR this year. So as part of my role on the journal, I keep track of the data and trends in environmental law scholarship. This morning, I'd like to give you a brief snapshot of the environmental publication data we have reported this year. Next slide. So as Bruce described, we have an established methodology for evaluating environmental articles and collecting data. And if you are more interested in having a detailed look at this process, the full information on our methodology can be found at this link on the ELI website. So this past year, we analyzed 206 environmental law articles. When members read through an article to assess whether it's an environmental article, they consider whether environmental law and policy are a substantial focus of the article and whether environmental topics were given more than an incidental treatment and were integral to the main thrust of the article. Next slide. Of these 206 environmental law articles, 62 came from general law reviews and 144 came from environmental law journals. We define environmental law journals as US-based specialty journals listed in the environmental and land use law subject area of the most recent rankings compiled by the Washington and Lee University School of Law. Next slide. So ELPAR members classify all the articles into 10 topic categories, which are set out by the Environmental Law Reporter's Subject Matter Index. These topics include air, climate change, energy, governance, land use, natural resources, toxic substances, waste, water, and wildlife. Articles receive a primary topic and also a secondary topic if that's applicable. So the environmental articles published from August 2020 to July 2021 included 68 governance articles, 35 energy articles, 28 water articles, 26 climate change articles, 18 land use articles, 10 natural resource articles, 8 waste articles, 7 wildlife articles, 4 air articles, and 2 toxic substance articles. And you can see each grouped by percentages in this chart. Next slide. We also gathered data about article subtopics, mainly because the governance category casts a very wide net with 36 different subcategories. So these are all the subtopics per percentage. Next slide. We grouped all of the categories that were under 3% and grouped them into other in this pie chart for ease of understanding. This chart tracks the exact same data, and the most common topics within governance articles were environmental justice tied with international law. And they were followed by infrastructure, then corporate law and state governance. Then agencies and indigenous people both came in 6th place. Next slide. Out of our top 20 articles chosen for 2020 to 2021, 8 articles were from environmental journals and 12 were from general law reviews. Next slide. So within the top 20, we had a range of primary topics, with the most common being governance and climate change. You can see the secondary topics below, although not every article had a secondary topic. Next slide. In our top 20, 10 articles called for action by state and local governments as part of their proposal, and 5 called for action by either federal executive agencies or judicial actors. 4 articles called for updates to federal or international law, and 1 article proposed private governance measures. We had a great pool of articles to choose from this year, and we are excited to discuss some of them today. And with that, I will hand it back to Linda.
Great, thank you, Bruce and Jay. Terrific job. I always find it really interesting to see how the topics change over time. As you might imagine, when we started this 14 years ago, we didn't have any climate change articles or energy articles. So it's just interesting to watch how the trends evolve. I want to say a special thank you before I forget to the ELPAR students in Nashville that who are listening to this today. The class really did a terrific job this year of picking a great group of articles. And also I want to make sure, as Bruce did, to thank our All-Star Research Associate, Heather Luedke, for her incredible work on ELPAR for the past 2 years, and Colin Gibson-Tansel, who's managing the technology for us today. As he knows, we could not do this without him. And Victoria Dorward at Vanderbilt, who is just instrumental to our ELPAR work. So my job today is to move us along as smoothly as possible, and also deliberately, so we make sure we aren't talking over each other, which GoToWebinar does not like, and to try to just keep us running on time. So the way this is going to work is that the Vanderbilt student article editor will introduce the panel, and then the professor or professors will present the article for about 15 minutes. Then each panelist will comment for about 10, and then we'll give the professors a chance to respond to what they've heard from the expert commenters, and that's always, I think, a really interesting aspect of this. And then the student editor will kick off the Q&A with a question, and then we'll take questions from the audience and continue discussion among the panelists. We strongly encourage you to ask your questions as they arise during the panels. Don't wait till the very end. Use the question box in GoToWebinar, and I'll pose as many of your questions as I can during the Q&A section. And just a word about technology, and most importantly, patience. As we change panels, we apparently cannot mute mute the audio. So unfortunately, you will hear us testing the tech for each new panel while the conference is on a 10-minute break. Of course, you're free to come and go throughout the panels today. Just to re-enter the webinar, just use the same link you used this morning, and all attendees are muted. If you have any problems or questions, feel free to put them in the GoToWebinar question box. Those will only go to the conference organizers, and Heather or Colin can help you out. We always get this question, so I want to say that the slides from the presentations today, as well as a recording of today's conference, will be posted on the ELPAR website after the conference within a few days, as well as the speaker bios. And the schedule for today is available on the ELI events page where you register, but I'll remind everybody as we move forward which panel is next. Lastly, and I never used to say this 14 years ago, we will be tweeting during the conference, so please feel free to engage with us on social media. On Twitter, it's ELI.org. So I am going to hand it over now to Vanderbilt third-year law student Izzy Fishbach to introduce our wonderful first panel. Izzy?
Hi, everyone. Good morning. My name is Izzy Fishbach. I'm a third-year law student at Vanderbilt Law School, and I am the ELPAR article editor for our article, which is Environmental Citizen Suits and the Inequities of Races to the Top, authored by David E. Edelman and Jory Riley Diakun. I'll introduce these authors for you and tell you a little bit about them. David Edelman teaches and writes in the areas of environmental law, intellectual property law, and climate change policy. Professor Edelman's research focuses on the many interfaces between law and science. His articles have addressed such topics as the regulatory implications of emerging genomic technologies and the tensions between legal and scientific evidentiary standards. Professor Edelman clerked for the Honorable Samuel Conti of the United States District Court for the Northern District of California. Before entering academia, he was an attorney with the firm Covington and Burling and a senior attorney with the Natural Resources Defense Council. Prior to joining UT Law, he taught at the University of Arizona Rogers College of Law. Jory Riley Diakun joined EPA's Office of General Counsel in 2020 as an attorney advisor in the Pesticides and Toxic Substances Law Office. Prior to his work at EPA, he worked as a fellow at the University of Texas School of Law. He earned his BS in physics from the College of William and Mary and his JD from the University of Texas School of Law. We also have two wonderful commenters for you today. Our first commenter is Bina Reddy. Bina is a principal at Beveridge and Diamond PC, and Bina co-leads the firm's Toxic Torts and Mass Torts group and has served on the firm's management committee. Bina has devoted a substantial portion of her practice to litigation under federal environmental citizen supervisions. Her experience extends to all major environmental statutes, the Resource Conservation and Recovery Act, Clean Water Act, Clean Air Act, and even the Safe Drinking Water Act. She speaks and publishes on environmental litigation, and in particular, on the subject of novel uses of federal citizen suits. Our other commenter is Howard A. Lerner. Howard is an experienced public interest environmental and energy litigation attorney, serving as executive director of the Environmental Law and Policy Center. He is also an adjunct professor at the University of Michigan Law School, teaching advanced seminars on climate change and clean energy law, environmental constitutionalism, and sustainable development law. He received his JD from Harvard Law School and his BA with honors from the University of Michigan. And I'll hand it back to Linda.
Thank you so much. Professors, over to you to tell us about your article.
Okay, so I'm going to start off. We're going to split the presentation between myself and Jory. I wanted to start off by just thanking everyone associated with the Environmental Law and Policy Annual Review. I have even a greater appreciation for all of the work that goes into that. And really, we are both grateful for being selected, having our paper selected this year. I also want to thank Jory. It was a real pleasure working with him, both as a student and after he graduated from UT Law. And like I said, we're going to split things up. I'm going to talk about or provide just a general overview of our principal findings in the study. And Jory is going to talk about the implications and some of our recommendations. So what I want to do is start off with kind of three principal observations. At the highest level, what we find is the number of citizen suits filed in a given year is relatively small, and that the suits are not evenly distributed geographically around the country. They tend to be principally filed in states where there's strong public support for environmental protection, and state programs are relatively strong. Another point to keep in mind is roughly 50% of the cases are petitions for review, and an additional 28% of the cases have the federal government as a defendant in those cases. So we've got this distribution of cases that's really uneven geographically, and we've got a heavy emphasis on cases that involve the federal government as opposed to private parties. The other thing that we observe is significant differences across the different environmental statutes, particularly with regard to the balance of petitions for review, what we refer to as wholesale litigation, versus litigation involving specific federal actions or specific facilities. With regard to the claims, about 40% of the cases center on procedural claims, and only about 18% of the cases involve cases against private parties. This is particularly important with regard to citizen suits because a lot of controversy has existed around particularly private attorney general's cases and the potential for that to distort or impact federal or state implementation of environmental statutes. And a lot of the debate around citizen suits is centered on this type of case, and yet it's a relatively minor or small number of cases on an annual basis. One of the things we also wanted to look at was specific classes of cases, in part because of their significance or importance. So what we wanted to do was try and identify the number of environmental justice cases filed each year and the number of NIMBY cases filed each year. This was something that's not easy to do, both because of the limitations of the DOJ data that we were using and because of the challenges of coding the cases. So I want to qualify these numbers and say that they're subject to significant error bars or uncertainties, and we've just done the best we can with time and resources we had and the data we had available to us. But in either case, we find that there's a really small number of environmental justice cases filed in a given year and a relatively small number of NIMBY cases that are filed in a given year. And even if our numbers are off substantially, even by like a factor of 2, I think the numbers are relatively small, suggesting that we could certainly be doing a lot more with regard to the EJ cases, and also suggesting that despite the fact that there are a number of really high-profile cases that are sometimes characterized as NIMBY, that's not really representative of the bulk of the cases out there. The third point I want to start with is our data, when you look at them kind of collectively, are inconsistent with the sort of conventional views pro and con with regard to citizen suits. So proponents of citizen suits assert that they can be used as a backstop against lax enforcement or implementation of environmental regulations. And we're just not seeing that given the pattern and the number of cases that are filed on a given year. In addition, skeptics are concerned about citizen suits essentially co-opting or overriding the judgment of state or federal agencies with principal responsibility for implementing them. And again, we don't see evidence of that either. And so one of the central things we hope will come out of this case is the importance of understanding how citizen suits operate in practice, and therefore how we should be thinking about them. Let's see if I can advance this. Okay, good. So this first slide is really looking at the aggregate data. We're looking at the number of cases per year. It's broken down by statute. What we see is roughly 80% of the cases are filed under the Clean Air Act, Clean Water Act, NEPA, ESA, and MMPA. Each of those types of cases, or those cases filed under each of those statutes, makes up roughly 20% of the cases filed in a given year. Overall, the number of cases filed in a year is about 350 plus or minus 50. It's been pretty stable, although in the last few years, there's some indication that the number of Clean Water Act cases was diminishing. One of the most striking findings we have is the geographic distribution of cases. So this is looking at the number of cases by circuit, and it's broken down just to make this, more easy to interpret by the natural resource cases, cases filed under the pollution statutes, and cases filed under Superfund and RCRA. You might expect there to be a large number of cases in the DC circuit, both because most of the federal agencies are based in Washington, DC, and because of the unique status of the DC circuit itself, particularly with regard to Clean Air Act cases. You also might expect there to be a significant number of cases in the Ninth Circuit, particularly because about 60% of public lands are located in the states that are encompassed by the Ninth Circuit. But we even think taking that into account, the number of natural resource cases is pretty striking, even with that factored into your analysis. And we'll sort of illustrate why a little bit more rigorously later on. But particularly with regard to the cases under the pollution statutes, it's actually surprising to see so many in the Ninth Circuit, both because a number of the states have relatively low population, low urbanization, and relatively low industrialization, especially relative to states like Texas or Louisiana. And so we see this kind of geographic imbalance in the distribution of cases. We see that same geographic skew mirrored at the state level. So California kind of exists in a category all to itself. If we look at the natural resource law cases, we see this interesting divergence between states like Oregon, Montana, and Idaho in the Ninth Circuit versus states like Colorado and New Mexico in the 10th Circuit in terms of the relative number of cases, which again is suggesting that the cases aren't simply tracking, for example, the amount of federal land in a particular state, that there's form issues that seem to be an important factor with regard to where cases are filed. With regard to the pollution statutes, a state like Washington, which is so dominant relative, again, to states like Texas, Louisiana, I think is also really striking and suggesting that numbers or maybe concerns about implementation of environmental statutes isn't really the driver with regard to where cases are filed. Okay. When we look at case outcomes, this is looking at how the rates at which different classes of plaintiffs prevail in environmental lawsuits. So the percent in which defendants win, the percent in which plaintiffs win, the percent in which we have settlements by different classes of plaintiffs, so environmental, trade groups, corporations, state and local governments. And there are really just two observations I want to make here. The first is that we find that environmental organizations prevail consistently at higher rates than the other classes of plaintiffs. And the second thing is that we see quite a significant difference in the rates at which plaintiffs prevail across the different statutes. So for example, with the environmental NGOs, they prevail at substantially lower rates in cases under the National Environmental Policy Act. They still prevail at rates that are comparable to or greater than those of the other classes of plaintiffs. And so one thing that comes out of this is we find the data are at least suggestive of that environmental groups are at least as selective or more selective than the other classes of plaintiffs with regard to the cases they choose to file. So in addition to these broad descriptive statistics, we wanted to do some regression analysis to enable us to utilize some checks to see which were the predominant drivers in a kind of more formal statistical model. In particular, we wanted to have controls for the natural resource cases with regard to the amount of federal land in a state, and with regard to the pollution statutes with regard to the number of permanent facilities. We basically see two explanatory variables dominating our regression analysis. The first is the number of environmental NGOs in the states. And although this is a crude proxy, we view it as indicative, at least, of the public support for environmental protection in a state. And the second is whether a state falls within the Ninth Circuit or not. Again, sort of tracking the patterns and the descriptive statistics that we've already observed. In both cases, and for both natural resource cases and pollution cases, we find them as really powerful predictors of where cases are going to be filed. And so what we're finding is where there's strong support for environmental protection, cases are being filed there. Where a state is in the Ninth Circuit, which seems to be suggesting a significant factor in where a case is filed is the forum, is driving where cases are located geographically across the country. The last thing I'm going to talk about really briefly is attorney fee awards. And so these data, I just want to underline, are probably the least complete data in the DOJ database. And so there are, again, significant error bars associated with this, and we're trying to do the best we can with the data that we had. We think the sort of relative general trends are what matter most here. And so what we observe is, in terms of absolute amounts, attorneys' fees granted are relatively modest. Probably the median is most important statistical variable here, given the skew in the data. So maybe $40,000 or $50,000 in attorneys' fees early on, but that's also declining over time. So we not only observe relatively modest amounts of attorneys' fees granted, there's a relatively low percentage of cases in which attorneys' fees are granted, roughly 15% overall, or a little less than 40% of the cases in which plaintiffs prevail. And then it's also declining over time. And so again, one of the controversies over citizen suits is claims that one reason that they're filed is to obtain attorney's fees. We just think the amounts and the percentages of cases in which they're granted really are compelling evidence against those sorts of claims with regard to citizen suits. So I'm going to stop there and then turn it over to Joy to talk about the implications and our recommendations in the paper.
And I just want to remind everyone that the slides will be available on the ELI website. I think this is fascinating data. And also remind everyone to mute. I love when dogs can join the webinar, but it would be great if we can mute when we're not speaking.
And hopefully no dogs will set off mine, so I apologize in advance. I'm going to take 30 seconds out front of a very limited time here to disclaim that I'm here today in my personal capacity. I had the pleasure to work with David on this project before I joined EPA. So everything that I say today is my opinion, mine alone, and not that of the United States government or necessarily representative of the views of EPA. That all being said, I'm going to go ahead and quickly jump into a little bit of our reassessment of citizen suits. So based on the data that David presented, and he's touched on a few of these themes already, we kind of took three key takeaways about the commentary that has existed on the threats and promises of citizen suits. The first is that the number of citizen suits that are filed and the concentration of cases in certain jurisdictions largely forecloses critics' critique that citizen suits will conflict with agency priority setting and the preference for local communities. This is kind of tied, as David mentioned earlier, to the modest number of citizen suits that are filed and the clustering of those citizen suits. The second major takeaway is that the barriers to filing citizen suits and the difficulty of obtaining attorney's fees awards may exacerbate rather than mitigate, as proponents posit, the disparities between states in implementing and enforcing the environmental laws. This is kind of the core of where our paper's title came from, and our theory here is based on the data that we're seeing is the regressions do not show a significant connection between the rigor of enforcement in a particular state and where third-party citizen suits are filed. Rather, it seems to be that there's parochial behavior on the part of the litigants. The last of our major takeaways is that most citizen suits focus on the federal government, not private entities, and may involve what one might term wholesale challenges to broader actions like regulation, rather than retail challenges to discrete agency decisions or actions. And this does tend to be heavily tied to the structure of the statute. On one end is the CAA, which is overwhelmingly a wholesale statute, as David mentioned. On the other end would be NEPA, which is overwhelmingly retail, and everything else being kind of in the middle ground. David, can you advance the slide, please? So just to put this a little bit in perspective, we wanted to draw out something that's a little bit buried in our paper, and I'm going to leave you to read what's on the slide, but I'm going to focus on a particular example of the CWA. So during our 16-year sample period for the cases, there were roughly 19,000 facilities that were permitted to discharge pollutants. And during the 16-year period, as I said, there were between 10 and 11,000 federal or state enforcement actions. Despite this, citizens filed despite filing more citizen suits in any other area that were directed at private entities in this particular subcategory of cases, there were only 160 cases filed by citizens. And that accounts for just about 2% of the total activity of the federal government in that same time frame. So the federal activity really is dwarfing it. And so even if by a couple orders of magnitude, so even if the impact of an individual citizen suit is greater than the impact of an individual enforcement action by the federal government or the state government, the sheer volume of federal and state activity is significantly outweighing that of the individual actors in the citizen suit provisions. And I'm going to be sensitive to time, so let's go ahead and go to the last slide here. So based on our findings, we kind of put forward 3 key takeaways that might be potential avenues for reform. We were primarily focused on reforms that could be considered to be practical, or things that would be trying to exist within the existing climate of both politics and the conversation around citizen suits today. These are by no means exhaustive, and certainly additional data could provide additional creative thoughts, but our key takeaways were that we wanted to push for targeted reform in the legislation context to lower the barriers to entering to filing citizen suits, and to create incentives for filing them where they're most needed. David's going to talk a little bit more about this, I think, in the next slide, but I'm going to go ahead and move on for now from that one and talk a bit about enhancing transparency of the filing of citizen suits and improving coordination among environmental organizations, which was our second key reform. Here we thought about using the existing infrastructure for reporting citizen suits to provide a mechanism by which we can improve the information gathering that would allow both organizations themselves to better coordinate and conserve their resources, and also to allow us to better understand and dispel some of the myths that are around citizen suits, to allow us to hopefully allow them to calibrate them to actually serve the goals that they were intended to serve. The last major area that we want to talk a little bit about is providing education to judges. And the importance here is that data suggests that many judges, because of the concentration in particular areas and forums, many judges only have episodic exposure to environmental litigation. And so to the extent that they do, and the intense polarization around many cases, particularly citizen suit cases, this reform is directed at providing judges with the empirical context for how citizen suits operate and the important role that they could and may serve within the environmental law infrastructure, while combating any preconceptions that they might develop based on their limited exposure and the popular commentary around them. So I'm going to pass this back to David just to cover the last piece, and then we should be able to wrap it up.
Yeah, actually, I think what we should do, why don't we stop there, and maybe in the Q&A we can talk about some of the recommendations in a little bit greater detail, or in response to some of the questions that are raised, just to keep on time.
Works for me.
Well, that sounds great. And please, reminder to everyone, send your questions in. We've gotten a few, but we would like to get more. And I think we'll hand it over to our first commenter, Ms. Reddy.
All right. Hope everyone can hear me. Thank you all. It's a real pleasure to be here. My name is Bina Reddy, and as mentioned, I am a private practitioner, and my practice actually is primarily the defense of citizen suits. And I'll start off by saying that I'll confess I've wondered many times to myself about I practice in this space, and what are the actual numbers or trends that are associated with citizen suits, because from where I sit, it is really difficult to tell. And so it's really interesting to me to be involved in this conversation that is around an empirical analysis of these suits. And another thing that may be evident but is worth underscoring, I think, from my bio, is that I live in the world of retail suits. I live in the world of the private suits against private entities, but not exclusively, as I'll get to later. And this is basically almost been full time for me. And so my comments are going to represent that perspective. And that means that they're sort of necessarily anecdotal, and I hope that my experience as a private practitioner is helpful to the group to sort of shed light where I can on the disparities that are discussed in the article. And I guess I want to be the first to acknowledge that I recognize that the private suits do take on this disproportionately large profile, right, in light of the relatively small numbers that these suits represent. But having said that, let me talk about the private suits. And one of the points that I took away from the article at a general level is that the retail suits, private suits, don't really significantly advance the ball in terms of having the effect of raising or leveling the bar in terms of enforcement. And that's because they tend to be dominated by these site-specific permit challenges. So the impact of that kind of enforcement is going to be inherently limited. It's going to be limited to, okay, the enforcement at this particular location or facility. And so that's going to be of a limited impact in at best neutral in terms of moving that bar in enforcement. And I just want to offer that, as a full-time for many years practitioner defending citizen suits, the suits that I defend don't fit well in that profile. The private suits that I defend don't fit well. They are rarely about the numerical limits in a permit. They are not, okay, this is your discharge threshold and you have exceeded it, and here's the citizen suit. Those are always going to be claims, but they really exist mostly on the margins, at least in my experience. And the heart of the cases that I've defended now for many years, and I really can't overstate this. This is true consistently for me over a fairly long period, is that the heart of the cases are about narrative, qualitative terms in permits, and these are terms that exist in basically every permit. And I'm going to walk through a couple examples to sort of make this a little bit more concrete. But again, they are about terms that are going to be subject to interpretation. They're not numerical. They're not easy to call kind of a ball and strike. And often these are surprisingly questions of first impression. Sometimes the statute or the regulation will have a definition. The definition will often be circular, and there will just simply be almost no interpretation of what some of these terms mean. And I think it's, while again, the retail private suits represent this small slice, I would posit that the impact of these suits can be very large, and do in fact raise the bar. One of the most high profile examples of those that probably many in this audience are familiar with is the Formosa plastic suit in Texas. That was a Clean Water Act suit filed in 2019, I think, and that involved qualitative standards in a Clean Water Act permit, and specifically, so this is a case, and there's several of these that have been filed around the country involving the discharge of these fairly small plastic pellets into waterways that are a byproduct of the production process. And the permits here forbid discharges of floating solids in quote, other than trace amounts. So the case was, okay, what does trace amounts mean, right? And in that case, the plaintiffs introduced into evidence hundreds of bags of waste that were collected downstream of this particular facility. The judge there determined that trace meant very small or barely discernible, and concluded that the plaintiffs had provided sufficient evidence to meet this threshold, and there was a violation of this language other than in trace amounts. And you can draw a pretty straight line from that newly defined standard in a permit that exists in everybody's general permit to an immediate action on the part of state agencies where for at least the state agency in Texas, this is TCEQ, announced a clarification of its enforcement of this term, and they have started to rewrite all the general permits to interpret this in other than trace amounts to mean zero, right? So the impact of that is, there's hundreds of dischargers in Texas that have that language in their permit, and whether you sit on the side of the fence that thinks that's good or bad, it's just simply a fact that that is a raising of the bar via one interpretation by one district judge. And so I think it's hard to capture those sort of examples in looking at the data that you all very admirably put together from the DOJ database. But I do think it's worth flagging that in my experience, this is the litigation that I am seeing and that many are seeing, and at least I perceive there to be an uptick in it. And I'll just quickly touch a couple more examples in different statutes. So that was the Clean Water Act, and we actually saw that a resolution on the merits there. The next two were not resolved on the merits, but pose the same sort of issues. The second example is under the Safe Drinking Water Act, which is rarely litigated in a citizen suit context. There's a lot of complexity there. And I was involved in a Safe Drinking Water Act suit where really the question, the real central question in the case was, what does the word optimization mean in the lead and copper rule? And I'll just kind of cut straight to the point that that term, for purposes of controlling lead in drinking water, applies to literally every drinking water provider, right? And so the impact of that decision is massive, both in terms of the regulatory impact, the compliance impact, and also there's huge financial impacts with having to tweak how you treat drinking water. Those are going to require major changes. So again, what does optimization mean? That's a kind of question, and similarly with trace amounts, those are not issues that are going to be decided on a motion to dismiss. These cases are going to go some distance, right? And you will potentially get a ruling at some point on that, and they can have the kinds of impacts we saw with Formosa. The last one I'll mention, because I think it's a really interesting one, is under the Clean Air Act, and a term that's I'm sure everybody has crossed paths with is nuisance. A lot of Clean Air Act state implementation plans incorporate a nuisance provision. And so, I was involved in a case, again, there were on the margins questions about, did you exceed this limit? Did you exceed that limit? But the real question was, what does nuisance mean in the context of a Clean Air Act permit? That has sweeping implications, and also is interesting from kind of an academic perspective, because that traditionally is somewhat of a subjective inquiry. But regulation is supposed to be uniform. It shouldn't vary all that much. So I think I just want to kind of shine a little bit of a light on the litigation around narrative qualitative terms and the role they play, and what I see as real potential for raising that bar in terms of enforcement. The second point I want to make also comes from my experience, and it relates to the questions about whether citizen suits do or do not really align with local prerogatives, right? What do local communities want, and are these citizen suits really consistent with that? And I think the answer to that question is obviously it depends. And the answers those are incredibly complex questions. But in that vein, I'd like to offer sort of a caution on relying too much on statewide metrics as a proxy for local viewpoints, because at least in my experience, local views on environmental issues can vary dramatically, even across a single city, and they will reflect nuances in local politics. It is amazing what's really happening on the street level. And my thoughts on this are informed in large part by my experience defending municipalities in citizen suits when they are the regulated entity, because there, the issues of local views are often very sharp and easier to see. And that makes sense if you think about it, because citizen suits are often going to involve a claim for injunctive relief, and major injunctive measures can have extremely high price tags, especially if you're talking about changes to municipal infrastructure. And so the rubber really hits the road there when you're talking about, well, what does the local community want? Because the cost of that injunctive relief is ultimately going to be paid by taxpayers, right? And so then it becomes really crystallized. Well, do we want to pay for this? How much do we care about this? And there are really interesting questions there that I just say, I just want to offer. I know that it's difficult and we have to work with the data that we have, but like I said, this is kind of anecdotal, but it's been true in my experience, at least, that it's very, very hard to capture local politics. And wow, the impact of one city council race on your litigation you can feel it, and how it reverberates through the voices of the community. My last point, and I think I'm probably bumping up against the end of my time, is on so the ultimate question of how do we rectify this gap? How do we make this more balanced in terms of where these suits are being filed? And I have one comment, and then it sort of flows into maybe a question. And the comment is that, in my view, even the easy cases are not easy. You don't have a whole lot of attorneys walking around who are raising their hands to file citizen suits. They are complex. You have to expend some funds, and you don't know, as we've discussed, whether you'll recoup that in the form of getting your attorney's fees back, and that the technical and legal issues can be very arcane. And so I think, even if you're talking about one of those sort of simple suits where you have the publicly available data on, okay, here's your exceedance, open and shut case, it never works out that way. And that it's always been interesting to me that, with the national environmental organizations, I think that I have to suspect, at least in part, they have the success rates that they do because they are repeat players. They know how to do this. They come to the table with really knowledge that's hard to find other places. And they have local chapters. And I always wonder, you talked about coordination among the groups. Why, if it's not flowing to the local chapters in a meaningful way, why not? And I will say I don't really know whether it is or isn't, or the dynamics of how that works, but it always strikes me that at the end of the day, the locations of where the suits are filed are right there, a decision of the plaintiffs, and these organizations have so much institutional knowledge. It seems to me that they are a good place to start, particularly where they have these footprints throughout the country. So, I think that is it for my comments. I look forward to any questions, and I'm going to pass it back to Linda.
Bina, thank you so much. It's really interesting to hear from your perspective, and I was particularly interested in your observations about the local dynamic because I do a lot of work here in Nashville at the local level, and I have a feeling the authors will want to engage with some of your remarks. But we're going to now turn to our second expert commenter, who I think gets some kind of gold star or something, because I believe he is coming to us from Hawaii. Is that correct, Howard?
I am.
Thank you for being here. Over to you.
All right. Thank you, Linda, and thank you For all those at ELI and at the law school who organized the ELPAR forum, bravo. And thank you to the authors for a well put together and provocative paper. It's timely, and I really do look forward to reading the final article, which I think will be helpful in the field. The empirical analysis is helpful, but let me bring you some good news. In 2 regions of the country, excuse me, the Midwest and the Southeast, which aren't always viewed as having especially vigorous state level enforcement or strong environmental programs, there are a significant number of big deal substantive citizen suits being filed, prevailing, that involve both actions against private parties and actions against government. Okay, these are cases that are retail, but they have high leverage value. When it comes in the Midwest to clean water and protecting the Great Lakes, Bina was talking about local views. These are 80 to 90% plus public issues, okay? When you look at what the public views are in places like Toledo, Ohio, Northwest Indiana, Chicago, most of Illinois, and so forth, when it comes to the Clean Water Act, when it comes to protecting the Great Lakes, these are not just bipartisan issues, these are nonpartisan issues. And that's reflected by the congressional delegation in which both Republicans and Democrats have strongly supported protecting the Great Lakes. Okay, so why are all these cases happening? And I'll describe a little bit about what's happening in Indiana, Ohio, Illinois, Wisconsin, Michigan, Minnesota. In both regions, the Midwest and the Southeast, there are sophisticated public interest environmental legal advocacy groups that have the legal capacity, strong enough financial base, attorneys who know how to bring these sorts of citizen suits. In the Midwest, it's the Environmental Law and Policy Center, but also our good colleagues at Midwest Environmental Advocates, Earth Justice, the Sierra Club, and others. In the Southeast, it's the Southern Environmental Law Center and a number of other groups. So when you have a set of groups that bring legal sophistication, reasonably strong financial basis so they can take on a case involving a citizen suit, and folks who are talented at doing public interest litigation, you then have the situation to do the sorts of cases that I'll talk about right now. And there is indeed sort of a self-regulating component to this. We are looking at cases that raise the bar. We are looking at cases that have leverage value. We can't do everything at the Environmental Law and Policy Center. So one of the questions is always, is this a one-off case, or does this case raise the bar for others? And one piece of that is one of my former board chairs, who is the managing partner of a big law firm, put it. Look, my clients want to know that if they do things right and their competitor isn't, that if the federal government in a certain administration isn't coming after them, that there'll be a group like the Environmental Law and Policy Center or Earth Justice or the Southern Environmental Law Center who does it, because otherwise they're at a competitive disadvantage and they don't want to be in that situation. In terms of leverage, no general counsel, no CEO of an industrial polluter wants to be seen on the front page of the newspaper being labeled as a major polluter of the Great Lakes. I mean, that's just, nobody wants that. And that is some leverage. And that's part of the game. That's part of how do you play effective citizen suits. So let's look at some of the current litigation on our docket. And I'm not going to go through all of it, but I'll give you some examples. Indiana, not a state that is well known for strong environmental programs or enforcement. I don't have a reason to take a shot at Indiana. There's some very good people there, but it wouldn't come to most people's top of the list when they say, here are the strong programs. The Environmental Law and Policy Center and the Hoosier Environmental Council brought a Clean Water Act citizen enforcement suit in the U.S. District Court for the Northern District of Indiana involving ArcelorMittal, now Cleveland Cliffs, ammonia and cyanide pollution of the Little Calumet River that went into Lake Michigan. The company didn't say publicly what happened when it did, 72 hours when dead fish, 3,000 dead fish started showing up in the east arm of the Little Calumet River in Lake Michigan. People knew something was going on. They finally acknowledged there was ammonia and cyanide that got into the waterway that were spilled out. First aspect of bringing a citizen suit. You can file a 60-day notice letter, which is required under Clean Water Act, Clean Air Act, and so forth. But you need to spend some time negotiating with the state attorney general, the state EPA, and the federal authorities, because otherwise you're on the risk of at day 59, the federal and state governments step up and bring their own enforcement action. Now, that's not bad. We want the federal and state governments to do a very good job of enforcement. But we also want to make sure that if they're going to do it and overfile, that they really do it well. Okay? So that's a negotiation. It's a matter of making sure that if there is overfiling, it's really going to be vigorous and effective enforcement. And if for whatever reason the federal or state government aren't going to do that, you want to make sure that they get out of the way so that the citizen suit can be brought. So the best situation is the federal and state governments do it and do it well. But if they don't, that's the role of citizen suits under the Clean Air Act, the Clean Water Act, and the other environmental statutes. You got to work that within the 60-day period. Just without going chapter and verse in that lawsuit, plaintiffs, citizens groups brought that lawsuit. It was on the front pages of the newspapers. Turned out that there were a lot of permit violations. We believe they were significant. The defendants believed they were less significant. 2 years into the litigation, the federal and state governments decided to step up and move forward. There's now a consent decree that's been filed, more than $3 million of civil penalties, some additional environmental programs, including 127 acres of land that will eventually be donated through a land trust to expand the Indiana Dunes National Park. A series of provisions involving injunctive relief by which Cleveland Cliffs has to fix their steel mill, improve the operations, better equipment, better operating facilities, and so forth, and protocols. And there is almost $1 million of attorney's fees going to the Environmental Law and Policy Center as having brought the citizen suit action. So, I mean, this is a big deal case. It has retail value in the context you're talking about, but huge leverage value in terms of every other industrial facility along the Lake Michigan shoreline looks at this and says, we don't want to be in this position. So that's the leverage you get out of it, not just for one huge steel mill, but for the others along the way who look at it and say, yeah, we better make sure that we're doing things right. It's not just Indiana. We have clean water action suits involving the federal government and agricultural interests involving nutrient runoff pollution into Western Lake Erie that's led to severe toxic algae blooms every summer. That's about as substantive as you can get. Lake Erie is sadly the poster child for severe recurring toxic algae blooms. This litigation, which we brought, is designed to help clean that up over time. We've won some pretty significant victories. We're moving forward at this point into a potential consent decree with the state of Ohio and the federal government. Clean Air Act enforcement lawsuits against AEP in Ohio involving a number of coal plants, both in Ohio and Indiana. Clean Air Act enforcement suit that was recently settled with BP involving its violation of a consent decree in Northwest Indiana, or I should say alleged violation. The consent decree requires a fair number of fix-its and so forth going forward. Enforcement suits being brought, citizen suits in Wisconsin involving the laws designed to protect national wildlife refuges and NEPA. Clean Air Act enforcement suits in Illinois against Vistra in Peoria for its old Edwards coal plant violating opacity standards, too much particulates being emitted into the air. Suits in Michigan as well. An ozone action in the DC circuit because that's where it needs to go. These are all substantive They're a mix of private parties and governmental defendants. They are all, in most cases, very publicly visible, which increases the wholesale leverage value beyond the retail and leads to other defendants and other corporate counsel saying, uh-oh, are we going to have this problem at our plant, whether it's air pollution, water pollution, or other things involved. Important in terms of the role with the federal government. As we all know, sometimes we have EPAs and DOJs who are vigorous in enforcement, and other times less so. As I said before, we want federal and state governments to be tough, fair, effective enforcers, but when they're not, or when they just can't take on a particular matter, citizen suits are extraordinarily important. So some factors you might look at as you move David and Jory to finalizing your article. First of all, think about, on the numbers, how do you value what I'll call some of the bigger cases that have a lot of leverage versus what I'll call deadline cases that are filed that are much more tactical in terms of moving something forward. I don't know quite how you do that based on the data you have, but let's recognize that there is a difference there. Secondly, look to the resource question of who has the capacity to bring effective citizen suits of the substantive types you're talking about, involving private parties as well as governmental defendants. That tends to be places where you either have offices of the national environmental groups, such as in California, or places like the Southeast or the Midwest, where you have groups like the Southern Environmental Law Center, the Environmental Law and Policy Center, and groups like Earth Justice or EDF having an office, or good state groups like the Great Lakes Environmental Law Center or the Midwest Environmental Advocates, or local chapters of the Sierra Club that have had a litigation history. And those groups have to have a solid enough financial base so that they can bring these lawsuits, because nobody can look at this as attorney's fees alone are going to wind up supporting this work going forward. Attorney's fees are manna from heaven. We don't budget them going forward. We look at them as being an important part of our strategy. But when we get fees, it's episodic. It's somewhat unpredictable what year we're going to get them. Sometimes they're vigorously opposed in court, sometimes not. Sometimes judges look at them as being entirely justifiable. Sometimes judges have a lot of questions about it. There's a question of what rate is used and so forth, how many hours versus how long you litigate it. Your points about ways of reforming to make more predictable attorney's fees award, I think, are important to your analysis. Because when you have the attorney's fees award, that really does provide some incentive for both public interest law organizations and private parties to bring citizen suits, knowing that they have a meaningful possibility of serious attorney's fees being awarded. That shouldn't become as difficult as it sometimes is, and it shouldn't necessarily become the ancillary litigation that it occasionally becomes. When we get attorney's fees, we're entitled to, if you will, fees on fees if we need to battle the attorney's fees. Frankly, I prefer not to go in that direction. We do it when we need to, but we ought to be able to find a way of resolving it without having ancillary fees on fees battles. But in short, citizen suits are important. We all recognize it. And they're especially important where you have, for whatever combination of reasons in particular years, particular administrations, either federal governments or state governments that aren't stepping up when it comes to tough but fair and vigorous enforcement. We need to make it work better. But I think the system in some places perhaps is a little bit more aggressive in terms of qualitative impacts substantively than some of the numbers you have may indicate in terms of numbers of suits. And I get it from your analysis that because the DC Circuit is where so many cases need to be filed, of course the numbers will be higher there. And the Ninth Circuit in some ways is something of a special case. I'd encourage you to look at, if you take out the Ninth and DC Circuit, what are the differences that you're seeing between the other circuits that seem to be relatively flat in your graph? Are some of them more or less in what types of suits? But thank you for your work on the paper, and thank you to ELI for convening us.
And thank you for taking the time from a vacation in Hawaii to join us. Really interesting to hear your, on the ground sort of take on the data. We have some great questions coming in, but I do want to give the authors a chance to respond to what they've heard. So I'm going to hand it back to them to comment on the comments.
Okay, great. So Jory, I'll just respond to a few things, and then you should weigh in as well. First of all, these are really, really valuable, incredibly helpful comments that both of you have made, and really appreciate them. I think one of the hardest things in doing this type of empirical work is, addressed by the questions that you raised, which is just counting cases doesn't take into account the kind of weight or leverage associated with them. And in some ways, you guys have given us ideas for, if we wanted to go back to the data, we might be able to categorize cases in a more nuanced way that would capture the nature of the claims that are being made. For example, if it was an interpretive question that would have broad implications that would apply to many different facilities, that we might try and weight that, or at least categorize it differently than sort of narrow cases involving specific violations of a standard and a permit. And so I guess more than anything, I want to sort of cop to, yeah, that's a very hard thing to do. And in some ways, I think you guys have given us some ideas about how we might think about that. One question I sort of had was, if there was some way that when you have kind of impact litigation like this that comes down, that observably alters the behavior of other entities, and if there were some way for us to obtain that information, that would also be a way for us to sort of, look or value or weight the impact of a specific case. I don't think it would be easy to do it all, and I guess the question is how visible, or whether you could quantify that in any kind of meaningful way. But that was like one thing that came up for both of the comments that you guys made. So, Bina, I really, it's interesting to me. So in part, what you're sort of arguing is the dichotomy that we're drawing between kind of wholesale litigation and retail litigation is somewhat a false dichotomy, because the costs associated with bringing these cases almost invariably want significant leverage. And so it's not going to be something, a case that is going to be rare for it to be delimited to a specific facility, for example, just because Howard, I think you've alluded to this too, the leverage isn't there given the cost of undertaking these disputes. And again, that makes sense to me. And in some ways, it sort of shows you guys are highlighting, I think more precisely than we do in the case, just how important leverage is. We see that reflected in the balance between, what we're referring to as wholesale versus retail cases. And you're saying actually the balance is even skewed more towards wholesale-like litigation because leverage is so important and resources are so constrained. And so in some ways, I think that's a nice, a more maybe nuanced way that you're suggesting that we should understand even the more retail litigation, but in some respects, it's sort of consistent with the story that we're telling. With regard to alignment with local views, again, I hope that we were reasonably qualified in the sort of the limited data that we had available to us, and I guess all I can say is, I hear you, and we certainly didn't want to overstate that point. I think maybe at a really broad level, we're seeing, cases being more consistently brought, certainly in states that have reputations for having kind of more robust implementation of environmental regulations and policies. I think that's fair. But the sort of more local differences and conflicts, I think that's really interesting. And again, it would be interesting to think about whether there would be some way in which we could capture that more systematically in even trying to do an empirical study of it. Why don't I stop there? And Jory, why don't you weigh in? Because I think
yeah. So I want to quickly give a little bit of a peek behind the curtain, as it were, on how we thought about the question, Bina, that you raised on dealing with what does it mean to be aligned with local interests? Because I thought that you made a really great point, and so one of the most challenging pieces of all of the types of categorization when you get right down to dealing with these, from the initial point that David was raising about how do we develop a metric for understanding what is the relative merit or impact of a particular piece of litigation in the grand scheme versus what is a less impactful piece of litigation, and also developing these metrics for how to judge or ascertain kind of even a basic understanding of what is a local preference, or what is in some way aligned with a parochial interest of an organization. And to Howard, your point, I think we did spend a bit of time trying to think about, like, where are these organizations that have the resources to conduct these litigations situated, and it is a very challenging thing to find any kind of data on this. So you're left in a lot of ways with kind of more aggregated data. Oftentimes you're resource limited. So for us, at least, it would have been, I think you probably could ascertain, for example, some political data. You can fracture down all the way to the census districts, or voting districts or whatnot. So we could probably look to that if somebody had enough resources to really dig in and try to do an analysis to fracture it down into the pieces. I do think there might be some data there. I would be very interested to see if in a subsequent analysis somebody could come up with a metric that better kind of fixes it, because we did spend a significant amount of time when we were initially drafting it, batting back and forth around lots of different ideas about what kinds of data that is available might be a good proxy for either the particular local support a NGO might have, or the particular local support that might exist for the type of environmental litigation that was being taken place. So just putting that out there as the first piece. And I do think a lot of this highlights, a lot of the comments highlight one of, I think, the central pieces that is underpinning one of our big takeaways, is that more data would be very helpful. More data to understand how and why we litigate the way that we do, and how and why we choose the cases that we do and where they end up being filed, is of great value to kind of understand whether or not citizen suits are fulfilling their promise of the basic functions that we understand them to mean. And so I think in a lot of ways, as David was alluding, our metrics are limited very much by the data. And so to the extent that there is additional data that we can, as a community of attorneys and community of environmentally interest aligned people, develop more data that would allow us to better understand exactly what is going on and why it's going on, it would go a long way to helping build a better framework to understand whether or not we need and how to reform it.
You know, Jory and David, there's a fair amount of polling data, particularly on water issues around the Midwest and Great Lakes, done by some of the top pollsters in the country. I'll send it your way. I think we'll give you some of the empirical data you need. And it basically is showing, protecting clean water, protecting Lake Erie, for example. This is an 80% public issue. And it's an 80% issue when people are asked, if it winds up costing more in terms of wastewater treatment facilities, are you willing to pay it? It's just not a close issue. Polling was done, among other people, by Ann Selzer, who's one of the top pollsters in the country. I'll send it your way.
So one thing I do want to note on the concept of looking into the particular litigations that would be very valuable. So I spent a fair amount of time during this project going in and trying to categorize all of these cases. And with one case, it's fine. You open up the complaint and you take a quick look and you peek at what exactly is being argued within the context, what are the statutes, et cetera. And with 20 cases, it's fine, but resource intensive. And with 150 cases, it's fine, but more resource intensive. And with 10,000 cases, it's next to impossible for one person to do it. So part of the other thing that is underpinning a lot of this too, that would be great if additional people who are looking into right or research in this area wanted to undertake, is to try to help us develop as a community what exactly is in some of these cases, because it's very hard to get down, I think, to the nuts and bolts even of sometimes what is the central issue that's driving this case outside of the particular claims that are being raised when you're looking at it in a big aggregate, and when you're looking at many cases over many years. And then I guess the last thing I'll throw on there too is that I think it's important to note that we did have to pull, there are some cases that have such mass impact that we did have to remove them from parts of the data set. The good examples of these are the Volkswagen cases, the MDL in Louisiana on the Deepwater Horizon. There are some things that also have these huge impacts that are really kind of linked litigations that you can see even in the aggregation of the data set, to the extent that they might obscure everything else. And so that kind of, I think, how it goes to your point about one of the things that might be interesting, I agree, to look at would be to take the Ninth and the DC Circuit out and see if we can discern more about local trends.
All right, I want to make sure we have a lot of great questions, and we're going to have our Vanderbilt law student kick it off with a first question, and then we'll go to more audience questions.
Thank you, Linda. So this question is for the authors or the commenters, anybody who has some insight on it. My question is fairly basic, but I think important. In your opinion, which environmental statute, the largest environmental statutes, RCRA, the Clean Water Act, Clean Air Act, things of that nature, which statute could and would most benefit from an aggressive increase in litigation aimed at the statute's enforcement?
So, I just have a rough intuition, and maybe Bina and Howard will have a different sense of things. There's relatively little, if we're thinking about it from an enforcement perspective, which is sort of the way you framed it, there are relatively few cases filed under the Clean Air Act, in part because of the complexity of those cases. And so anything that would provide more resources or incentives, particularly under that statute, I think would be valuable. The Clean Water Act, because of the reporting requirements and the relative, and I want to emphasize relative ease of bringing those sorts of cases, we see a much higher volume of cases there. So, just in terms of relative numbers, it seems like the Clean Air Act would be one area where if there's any place where you'd like to see more litigation, or it seems like there's relatively little litigation, that would be the statute that I would point to.
Does anyone else want to jump in on that?
I was going to mulled it quickly, and I was going to also suggest the Clean Air Act. I guess not so much, in addition to the enforcement reason, but also just in terms of the impact of that pollution, right, on communities. It's just inherently, right, it's bigger, it reaches more. And I'll just add that I think there's really interesting things going on in terms of citizen monitoring and really quickly evolving technology in terms of measuring pollutants in the air. There's going to be some really complicated evidentiary battles about that, which very complicated, but I want to flag that's kind of right there. It's there. It's right. It's maybe happened or just about to happen, I think, in the air context.
That's interesting, because that was one of the first questions I wanted to pose, was about citizen scientists and what role they may start to play in these cases, and if they are ready. And one of the people asked, what are the Dover considerations?
Here, let me address that one a little bit, because at the Environmental Law and Policy Center, we actually run the largest clean air quality monitoring citizen science project in the country. We have more than 100 air quality monitors. They're handheld. They're about the size of 2 cell phones put together. And we work with community groups around Chicago and now Milwaukee to gather the data. The data is uploaded, it's put onto maps, and you get a very good idea where particulate pollution is especially high. There are Dover issues, as you're pointing out, Linda. This is citizen data. It's important indicative data. It's not necessarily yet ready for prime time in terms of, federal standard enforcement data, but it gives you a pretty good picture of what's going on. Keep in mind, from a methodological standpoint, David and Jory, the clean air cases, and I agree with you, they're very important in terms of citizen suits. Many of them will actually show up in the DC circuit, not in the local circuits. So for example, if you think that 2 counties in Indiana and 2 counties in Illinois ought to be redesignated in terms of ozone non-attainment, that action gets brought in the DC circuit. It doesn't get brought usually in the local district court or in the local circuit. So from a methodological standpoint for your paper, that's a matter of, the choice of forum is those clean air cases often go to the DC circuit because they involve decisions being made by US EPA at a national level. But as a practical matter, there are decisions being made at the regional level by EPA with the state EPA, but the actual action comes out of Washington, so you're going to the DC circuit. So that, let me just flag that methodological problem. Clean Air Act is certainly one where more vigorous citizen enforcement is not only desirable, it's necessary. A lot of this turns, of course, on the peculiarities and I don't mean that, let me say particularities more so than peculiarities. Sometimes at a state EPA, there's just a crack team of people who've been working on clean air issues for the last 15 years who are terrific, and they've stayed at the agency. The water division perhaps is not as strong. Other places, it's the opposite. Some places, there's some terrific staff who know RCRA really well and do a great job of it. Other places, RCRA is underutilized and provides an opportunity for what you're discussing. Ditto with the regional, the EPA regions. You've had a lot of retirements at EPA during the Trump administration. It may well be that the division that deals with RCRA has been gutted, but the people who are dealing with clean air have stayed, or vice versa. So you really have to look at what's going on with the particular state EPAs and what's going on at the particular regional offices.
So we have so many great questions. I was going to say, could I just throw out a couple others, and maybe we'll do this like Jeopardy. Whoever answers first, we'll try to do a quick answer and get to a few of them. We have several about PFAS substances and whether there's an uptick in cases trying to address PFAS substances under Clean Water Act or RCRA. Anyone want to
address that one? Yeah, so that's outside our empirical data set for this one here. A lot of the PFAS stuff, I do know that there is I can just say as an empirical matter that there is a upcoming toxics uptick. If we were to redo this study that covers now, there would be a lot more on toxics than there was during the sample period that we looked at in our paper.
Great. We have several questions about attorney's fees and why it's so difficult. What's leading to the disparities, and another question about whether there's been legislative action at the state level on attorney's fees that could impact this. Anyone want to jump?
I mean, maybe Howard will know this better. We spoke to people anecdotally, and the impression that we got from those discussions was DOJ in particular was often opposing attorney's fees pretty aggressively. And then just a general pattern of judges being over time less and less willing to grant attorney's fees or more skeptical about them. But that's not anything systematic. We've got our kind of broad numbers that we showed you. That's more anecdotal, talking to environmental litigators, mostly really from environmental NGOs.
You know, David, I think that's a fair observation. And frankly, it turns on the federal administration. The Trump administration, the Department of Justice, was pretty vigorous in terms of challenging and pushing back and trying to limit attorneys' fees. We hope that, you know, with Todd Kim coming in at ENRD in the current Department of Justice, people coming in at EPA and so forth, that there's going to be a different view. And that's not going to be that DOJ isn't going to do its job. The DOJ job is to protect the taxpayers. We get that. But hopefully there'll be a little bit of a different take on what are appropriate attorneys' fees from the new Biden administration than there was during the Trump administration. Let me just say it that simply.
I'm going to ask one, I'm going to let us go over just a little bit because the question came in that was something we talked about a lot in our class discussion about your article. And the question relates to judicial education being really important and asking the authors for a little more detail on how they would propose to accomplish that. And I'll just do a disclaimer, of course, Environmental Law Institute does some judicial training, but what thoughts did you have on this? And we'll close with that. I don't want to go too far over.
So I'll start, and again, Jory, you can weigh in. You know, I think part of the sense is that they're high-profile cases. Let's say some of the challenges to natural gas pipelines. They get an enormous amount of attention, and are suggestive that citizen suits are brought much more widely than they actually are in fact. And so, you know, just at a very basic level, what we wanted to do, and also taking into account some of the comments that we've received today, is try and give judges a more representative sense of the nature of citizen suits, how frequently they're filed, what their impacts are, these questions about alignments with community values, and some of the complexities around them as well, rather than judicial perception being driven by the most high-profile salient cases, which we really do not believe are representative of actually how the pattern of litigation out there. So that's sort of, you know, basically drawing on these results as well as any other results that we could draw on. It would be wonderful actually to do something where you have attorneys that are both bringing these cases and also defending them to discuss them as well. I think that would be a really valuable thing to do.
You know, David, one of the things that would be fascinating. One of the things that would be fascinating, given the polarized era that we live in and the closed information ecosystems, is thinking about what are the ways to communicate with those judges who might have a skewed sense of this. It may not be a traditional approach, but I think that's a fascinating thing. This has been a wonderful discussion. I'll pass it back to Linda because I know we're running out of time. Really helpful.
I know. It's so many great questions. I hate to cut this off, but we are going to thank you for an absolutely terrific panel. Thank you. Thank you. There'd be a ton of applause if we were in person. We're going to take a few-minute break here, during which time the audio will be live, as I mentioned. So we're going to be testing the tech for the next setup. We hope you will join us for the rest of the panels. Up next is the discussion of the article Caremark and ESG Perfect Together. We will reconvene in about 14 minutes. Thank you again to our wonderful panel.
Thank you.
Thank you.
All right, we're going to get started. Welcome back to our second panel, and we are ready to jump right in. But I am going to remind you all in the audience to send your questions in the question box on the GoToWebinar. We want to get them as we move along and not wait until the very end. Also, a reminder that the slides we're using today will be available on the ELI ELPAR website. So I am going to hand it over to third-year law student Paul Dambrosio to introduce our speakers. Paul.
Hello, everyone. My name is Paul Dambrosio. I am a 3L at Vanderbilt Law School and an articles editor for ELPAR. And I'm here to introduce our second article, Caremark and ESG, Perfect Together, by Leo Strine, Kirby Smith, and Riley Steele. Leo Strine is a graduate of University of Pennsylvania Carey School of Law and is currently the Michael L. Wachter Distinguished Fellow at Penn Law School, as well as the Ira M. Milstein Distinguished Senior Fellow at the Milstein Center at Columbia Law School, a Senior Fellow at Harvard's Program on Corporate Governance, a Henry Crown Fellow at the Aspen Institute, and is also of counsel at Wachtell, Lipton, Rosen, and Katz. But he is most famous for his work as the Chancellor of Delaware and the Chief Justice of the Delaware Supreme Court, where he wrote countless landmark corporate law opinions that are staples in every law student's corporation's casebook, including my personal favorite, the MFW shareholders litigation. Riley Steele is a PhD student in the Department of Politics at Princeton University. A graduate of Columbia Law School, he was previously an associate at Cravath, Swaine, and Moore, and served as a Milstein Fellow for the United States Senate Committee on Banking, Housing, and Urban Affairs. And he clerked for Chief Justice Strine a couple of years ago. Unfortunately, our third author on this paper, Kirby Smith, cannot be here today, but he is a member of Bridgeport Partners, which is a private investment firm with a long-term value-oriented approach to investing across public and private markets. He's a graduate of University of Chicago Law School, previously worked as an associate at Wachtell, served as a law clerk to Judge Andrew Hurwitz on the Ninth Circuit, and also clerked for Chief Justice Strine. I believe he was a co-clerk with Riley. For this article, we also have, unfortunately, only two esteemed panelists now. Our third one could not be here. But they're Jonas Cron, Todd Phillips, and unfortunately, Margaret Peloso could not be here today.
Paul, Maggie's just joined us, so we can add you back into the pile.
Sorry, I was looking at my notes and not see the camera. Welcome. Sorry. Sorry. All three esteemed panelists are here, and they will be introduced in full. Jonas Cron is a graduate of Vermont Law School and is the Chief Advocacy Officer at Trillium Asset Management, an investment firm focused on ESG and responsible investing. He previously worked as an environmental attorney and a public defender, and also serves as the Secretary of the Board for the U.S. Forum for Sustainable and Responsible Investment. Margaret Peloso is a graduate of Stanford Law School and a partner at Vinson & Elkins in Washington, D.C. Her practice focuses on climate change risk management and environmental litigation, and she also serves as V&E's lead sustainability partner. She also holds a PhD from Duke and has written extensively on environmental law, including a book titled Adapting to Rising Sea Levels, excuse me. Todd Phillips is the Director of Financial Regulatory and Corporate Governance at the Center for American Progress. A graduate of Michigan Law School, he previously worked as an attorney for the Federal Deposit Insurance Corporation, the Administrative Conference of the United States, and through the Oversight and Reform Committee for the U.S. House of Representatives. That is all, and I'll turn it over to our speakers.
And as you can see, we have assembled a group of real underachievers. And so I think this is going to be a fantastic discussion. And Professor Strine, we're going to have you kick it off.
Thank you, Linda. Thank you, Paul, for the gracious introductions. It was never, I knew it was time to leave the bench because I could never have a better year than having Riley Steele and Kirby Smith as my law clerks. So you always want to know when you hit that high water mark. And so it's an honor to be with you all, and I thank the host for putting on such a timely panel. I think it's fair to say I'm going to kick it off, and then I'm going to turn to Riley. We'll probably go a little bit from the general to the particular. We have slides for you all that are really meant for you to take away more than for us to sort of use them, right, Riley? We're not going to put you through it. What we really want to bring to the table today is a way of thinking about these issues that could be helpful to making more progress towards something that we all hope for, which is respect for our environment, and particularly addressing what humans have done in terms of carbon and methane and other emissions and their effect on the Earth's climate. One of the perspectives I think that Riley, Kirby, and I all bring to bear is that, you know, in a perfect world, the legitimacy of the Republic would be brought to bear to solve most problems. And that is importantly remains the case. But for a lot of reasons we've written about and talked about in other papers, not just me, but also Riley did work alone on this early in his scholarly career. You know, it's the governmental process itself is not adequate to respond to everything, and there's increased pressure on the business community to address issues like climate. But there's been a tendency in American public policy on many fronts in the last 25 years to be honestly cheap, opportunistic, and of the moment. The cooling saucer of our Constitution, as Washington put it, the United States Senate is increasingly the most reflexive body, not most reflective. Public policy is not the result of multi-year, interdisciplinary efforts by members of the Congress who are more committed to establish statutory regimes and getting them right. It's not that way much anymore. And that's a problem for making progress on this important front. And so business has been put front and center. But realize this is just the latest wave, right? ESG, I call it ESG because I add an E for employees, and I'm going to come back to that in terms of climate. But it used to be called corporate social responsibility. And in between that, we had the focus on TSR, total stock return, which has never gone away and will never go away. And companies have been told to manage to the market. Companies have been told to do whatever their stockholders want them to do. Companies have been told to have votes on pay every year that are votes on generalized outrage. And they're now being asked to make money and be good to all their stakeholders, which I always thought was the core mission. But they're being asked to do all these new things without, frankly, being given much more room to and discretion to balance interests over the long term and focus on sustainable wealth creation. And part of what we wanted to do in this article, along many dimensions, was to provide a roadmap for companies to think about this and to actually meet these competing demands in an efficient and effective way. And there's not a smooth road, for example, for a company like ExxonMobil to transform itself from an energy producing company that's carbon intensive to one that's not. And I've said to my friends that the little engine that did is, where will they be there at every meeting? And when the earnings are not smooth to get there, will they be able to do that? And these challenges exist for every company, not just in the environmental front. So what is our key insight? Well, our key insight is to remind people a little bit about what we do in this country in terms of chartering corporations, which is whatever the debate about Milton Friedman and all this stuff, the reality is the first obligation of a chartered business in the United States is to do lawful business only by lawful means. You can't pursue profit outside the bounds of the law. We also realize, though, that companies are under competitive pressure and that companies also are under pressure to go beyond the law or to state their values on things. And that sometimes when busy people get hit with situational stuff that's not thought out so well, they don't do it so well. And what we have perceived is if you look at the structure of companies and how they address ESG issues, it's not that well thought out. And you often have the environment, the E for environment done in one place for sustainability reports and for complying with the core statutes that the company must comply with a different group of people. We forget that where companies rub up against society is typically where the law rubs up against them. And what we propose is an efficient way of thinking about these things. And we base it on evidence. And the reality is that keeping an eye on the legal bottom line makes sure a company recognizes what society thinks is important, and so it doesn't become a founder's cult of personality, where they're good to one stakeholder but don't recognize that society expects a broad range of interests. And by the way, that was a profound problem in corporate America. Many people talk very high-mindedly about the environment while not treating their workers particularly well, for example. But the other thing is, we know that there are two groups of people. Many of us like to understand a three-letter word, WHY. And many of us do better when we understand why we're being asked to do something. And so the values you set, for example, around the environment, and articulating them in a way where people understand why it's a good thing to do, how it relates to the company's role, how it relates to our society. For many of us, that has a real uplifting effect in our willingness to do our part. But we all know that there are grumpier people who will only do something if they have to do it. And so the legal bottom line not only helps you not miss a risk, it gives a certain oomph to what you're doing. But these things are not unrelated. And the other thing I think what Riley and I will talk about, I'm going to turn it over to him in some specifics of how corporate America could potentially do better, particularly as the environment, is you don't have time to do related functions twice. You risk doing them in inconsistent ways, and duplication itself is a cost. Employees are busy, managers are busy, and you want to do things effectively. So if you actually say that as to our environmental responsibility, we're going to have a focus on, of course, meeting the legal bottom line. And one of the best ways to meet the legal bottom line is to meet the higher goals we have set. We're not asking you to do things twice. We're asking you to do them once and well. We're using all of our efforts. We're using our disclosure, not just as some beard, right, to hide how bald our head is on top, but to actually as a way of looking at how we do business and to catch issues and to improve our operations. And we're not going to tell one story outside of our core financial statements and to our regulators, and we're going to put it all in an integrated approach. And that's what we're talking about, is a way of thinking that actually is effective. And to be effective, you have to be efficient. One last policy point, probably just a personal privilege. I say you need an E for employees because our system of market system cannot work and our society cannot work if the corporate sector is not good to those people most responsible for their success, which is their workers. This is a very climate salient issue. All of us have used carbon produced energy. All of us have used things that generate methane. We are all responsible for how we got here. And the good men and women who work in companies in the energy sector should not be demonized. They need to be brought along. And history tells us that if it's a choice between people being able to feed their families and have economic security and things like the environment, it tends that the environment doesn't do so well. And so I'd urge us all to realize that we're, as much as that it's a collective responsibility issue, that the way we talk about these things and the concern and consideration we have for the people who face economic dislocation is really important to solving it. And honestly, these people have huge amounts of talent and experience and are really well positioned to help us make that transition. But I think our point is to make money the right way, right, Riley? You got to be good to all your stakeholders and not externalize. You can't just fetishize one. And so I'm going to turn it over to my friend Riley. And if I took too much time, Riley, I apologize.
No worries at all, Chief. Thank you for having us here. I think we only have a few more minutes left, so I'm just going to sort of give a broad overview of how you practically would implement this thing. And if you want more detail, you can turn to the slides or the paper itself. In the paper, we cover the rise of institutional investors and how they've increasingly focused on ESG. We cover the Caremark case law and how that very much aligns, the sorts of cases that are being brought very much aligns the sorts of concerns that investors have expressed interest in with respect to ESG. But I'll sort of just glide over that and sort of get to the practical of how you might implement this sort of system. So skipping through all these slides here. Okay, so our basic solution, as the chief alluded to, is you return to first principles. As expressed by Karamark, the first obligation of any corporation under Delaware law is to conduct lawful business by lawful means, and use that as a sort of starting point for figuring out where your ESG concerns might also lie, because there's a lot of overlap between those two things. And under Delaware law, Karamark and the business judgment rule provides you a lot of flexibility about how to manage these sorts of risks. And that can be a useful way for corporations to approach this. So we cover the case law here of Karamark. We have a big example of Boeing, but we'll just sort of skip over that here. Sorry, there are a lot of slides here. The basic way you're going to cover this is, right now boards have oftentimes relied a lot on audit committees for these sorts of functions, and we think that's problematic. So we propose integrating these ESG functions into all of the board's committees, and not just putting in the audit committee, which is already overburdened with compliance work and with addressing financial concerns, and that's reflected in the composition of these committees as well. So rather than just lodging everything in the audit committee, we propose that the board, distribute these ESG functions across committees. And in some cases where there might be a sort of mission critical business risk that, business and legal compliance risk that has a sort of ESG tint to it, it might make sense to have a specialized committee to deal with those sorts of risk. And this is reflected pretty clearly in the Karamark case law and landmark Marshland opinion that the Chief Justice authored, where the company had some pretty serious food safety risks, and it didn't have any sort of committee set up to deal with that. Had that company had this sort of committee, they might have been able to manage that risk more effectively, both the legal risk and the sort of public relations fallout that ensued as well. This was an ice cream company, and they had to recall their products, so that was harmful to the bottom line. It hurt their image. And having set up this sort of having these processes in place to start with would have helped both manage that legal risk and the sort of ESG risk as well. And these concerns are heightened even further for public corporations that have public shareholders and have to worry about demands from institutional investors as well. So that's the basic idea of it. I think I'll turn it over to our panelists now to sort of address this, and we look forward to your comments. Unless, Chief, you have anything else you want to add?
I think we have a minute and a half, and just to put a point on it. In some of these situations, you've had companies, and I don't want to pick on names, but a pharmaceutical company, right, Riley, that has no core committee at the board level that deals with the specific industry risk. Someone like Dr. Fauci could probably not serve on an audit committee because he would say, I'm not a financial expert, I'm a health and safety, I'm food safety. I could do a food safety committee, I could do a pharmacy committee, but you're going to put me on audit? And by the way, every public audit committee has enough to do. And same thing with aircraft safety or other things. And if you think about the energy transformation, right, ExxonMobil, the people who can help with climate, who can help with environmental, right, Riley, may not feel really comfortable doing accounting. And to give you another example, all the saliency around issues like employee pay or DEI or Me Too, a lot of the risk structures at companies actually culminated short of the board. And I think what we're saying, Riley, right, is to think about your board in a business-like way. Don't separate E for employee from E for employee for compliance and ESG. Don't do that with environmental. And remember that for your company, something where you could hurt society might be different than another company. And that you really have to think about, I think it's a way, Riley, we're also thinking about how companies are good citizens. And it's how they affect the world and their stakeholders. And that if you apply that good business judgment to that, you're going to be able to also, you're going to identify expertise you're going to want on the board. And by the way, you can find more women and minorities to do some of these things because in some of the sectors of the world, like the regulatory world and the military, people who know supply chain, who know human resources, who know safety, it's a more diverse group you can do it. And functionally, you'll be more effective. So it's a way of thinking, right, Riley, of bringing a business-like approach to this. And it's a way of thinking about it where you think about how you affect the world. And that's what drives, you're thinking more than just reacting to external things. So that's a little bit of overview. And now I think we are right at 11:35. So
I know you guys are amazing, staying on schedule, and obviously this is very thought-provoking because questions are pouring in. Great questions. I think we will turn first to Jonas for comments.
You can imagine what the Strine courtroom must have been like watching this perform here. Impressive.
Well, first, just thank you very much, and I really appreciate the author's thoughtfulness and forthrightness in sort of putting together this paper, and really I do find it very thought-provoking, and thank you for the opportunity to provide my thoughts and perspectives and on this. I guess I would just say a few things at the top as way of context for my own particular comments. And the first is that Trillium Asset Management, and I'll talk a little bit about who we are, is not representative of investors more broadly. You know, the investors of the world come in many shapes and stripes, and actually that's sort of the beauty of it, you know, is that we have a marketplace with a lot of different risk profiles, a lot of different goals, a lot of different philosophies of investment, and we have our own particular approach. Trillium has been around for 40 years. We're actually on our 40th anniversary, and we manage about $5.6 billion in assets. We do that through direct accounts with institutions and individuals, but also through a series of mutual funds. We also, and I should probably say this at the top as well, that 2 years ago we were acquired by a large global Australian financial services firm, Perpetual Limited. But our history actually, I think, provides some distinctions that I think are probably useful to draw out here when thinking about these questions and the questions raised in the piece. And that is the distinction between ESG or EESG and SRI. And I think Leo sort of mentioned this sort of earlier, that, you know, socially responsible investing was sort of the precursor. And to some extent, that's perhaps true, that you can look at it as sort of an evolution. But I think at the end of the day, that's actually not where we have found ourselves. That the field of investment as to, you know, whether you call it responsible investing or socially responsible investing or ESG investing or impact investing, has actually become quite nuanced and stratified into a lot of different pieces. And that there, you know, one way to sort of draw the lines is between ESG and SRI. And Trillium is really more in the SRI. And the distinction I would draw here is that ESG or ESG has a tendency to be focused more on risk, has to be focused more on materiality, on value, whereas SRI has a tendency to be more focused on values and making a set of value assertions in the way that we invest. And I think that's a distinction that's becoming increasingly important. And actually, we're seeing a lot more discussion of that in current events, and actually seeing how companies and investors are reacting to events in Russia and the Ukraine, and where are material decisions being made versus where are values decisions being made. So I think that might just sort of be one sort of initial observation on the paper, is I think that distinction between those two, roughly speaking, investment philosophies is something that I think could be drawn out more, and think about more about, you know, for the companies, about where their investors are at. Are their investors more focused on the ESG side, or are they more focused on the value side? And, you know, that may not be an answerable question, but to at least be aware that they are going to be getting feedback in different ways on those issues. And maybe as a way of illustrating this, and as a way to sort of get into some of the other pieces. So like I said, Trillium has been around for 40 years. One of the first sets of engagements that we did, and actually I should probably pause here and say, I'm the Chief Advocacy Officer. What we do is we invest in companies that we are very happy to be investing in because of the way they treat the environment, their social impacts, their governance structures. But every company can do better, and every company has opportunities to avoid backsliding or to become a leader. And so what I do in my team is engage those companies that we hold, that we are happy to be holding for ESG reasons and for SRI reasons, but to get them to take further steps. And we have a long history of using all the different tools of shareholder rights, whether that's shareholder proposals or whether that is organizing other investors or whether it's meeting directly with companies and engaging them in conversations or helping foster the public conversation through op-eds or other public actions to influence the direction that companies take on these environmental, social, and governance and employee issues. One example of this, going all the way back to our inception, or almost all the way back to our inception, actually back to the 90s, is that we started, and other investors as well, going to companies to ask them simply to promise not to fire their workers for being gay, for who they loved. And in the 90s, when we did that, companies would look at us like we had 10 heads. They thought that was totally insane. They did not know what we were talking about. And in the worst cases, they would be like, well, we don't have any gay employees. What are you talking about? Why would this be a matter of concern? And we weren't doing it with a body of evidence behind us that this is a materially important issue, that there's evidence that a company like this is going to outperform in terms of their stock performance or even other financial metrics. But it was the right thing to do. It was something that was consistent with our values and that we thought were going to be consistent with the company's values. And over the years, over the decades, we got more and more companies to make that commitment to integrate sexual orientation into their EEO-1 policies and eventually getting gender identity and gender expression into those policies. And to the point where eventually we didn't need to do that because the interpretation of federal law changed and said that actually gender identity and sexual orientation are protected. But I guess the important piece of this is that I think there's a large group of investors that are going to be advocating at companies for these issues that may not fit neatly within either financial arguments or that there is anything compliance related for them to deal with directly. You know, at the time, if you were going to be in compliance with your EEO-1 policies and and EEO law, you could fire people for being gay all you wanted. There was, you weren't going to be violating the law. You weren't going to be getting in trouble from a compliance point of view, but nevertheless, it was the wrong thing to do. And this is continuing to be the case that, there's a group of investors that are sort of on that vanguard that are looking at these issues that aren't necessarily going to be compliance related, aren't necessarily going to be material related. A couple other points here, and do I have 2 minutes left? Okay, I will very quickly go through these. One is that I really appreciated how the paper is sort of recentering around the human element and being other regarding, I think, as the phrase was being used in the paper. And I think that's critical to the conversation that we're having right now. And I really appreciate that it was building so much of the argument around that. I also actually really appreciated in the piece, in footnote 95, the discussion about signaling. There's a general effort these days to sort of say signaling is a bad thing, that companies are sort of just waving their hands and talking about, something important, but not actually doing something important. I actually think that's totally wrong. Human beings are signaling machines. That's what we do to each other, is that we signal what is appropriate and what is inappropriate. And markets are all about signaling. Market signal is vitally important to conveying to companies what they should be doing and not doing. And so I really did appreciate the paper picking up on that point. And I just sort of want to underscore that signaling does need to be backed up by substance, but the act of signaling is actually incredibly important. And it's something I think that we in the legal community probably should be thinking about a little bit more. Last but not least, just to make it very quick here, is that this question about where to house ESG, socially responsible responsibilities in the board structure, has been something that I've thought about for a long time, and I really do appreciate that. And I found the paper very persuasive that you shouldn't create a silo for that, and or some people would say the ESG ghetto. For a long time, I've actually been persuaded that it was helpful to have a single committee like that. Microsoft, I think, was a good example. They have a committee that is very much focused on the public policy aspects of the company, and that came out of the antitrust troubles that they dealt with in the late 90s and early aughts. And I thought for a long time that the company managed, contrary to all the way the other tech companies managed the pressures that they were feeling around the advances of technology and the relationship to society, that they manage that process much better than, say, Google or Alphabet or Apple, because they had that dedicated committee to the topic. But I do find this paper quite persuasive that while maybe Microsoft is the exception to prove the rule, that really we do need to see these issues not be ghettoized, not to be siloed, but actually to permeate through the governance structure. So I very much appreciate that fleshing out of that idea and sort of tying it back to Caremark. And I think that is probably my time, and I will stop there. But
that's great. Yeah, thank you so much. Really, really interesting perspective. And we're going to go to Margaret or Maggie next. And he has set the bar high because he cited footnote 95. So I hope that you read this as carefully as Jones did.
I know from Maggie's guest lecture in my class that we're going to hear similar level of detail. It's really impressive. The group of commentators we've assembled here.
Now you have set the bar way too high, Mike, but thanks everyone for having me. I'm sorry for sliding in at just the last minute here. So I really want to position my comments in the context of the events of the past week that have been really significant for those of us in the climate and corporate governance worlds. I have spent most of my career as an environmental litigator and then as a climate change lawyer. And over the last few years, a lot of that has really involved working very closely with both public and privately held companies and thinking about how should you build your climate governance. So this question of, do you put a single climate expert on your board and let them sit in the corner? How do you think about where they belong? And so I'm going to spend a few minutes talking about some of the proposed requirements in the SEC's climate disclosure rule that came out this week, because I thought that one of the things I would really love to hear from the authors on here is your thoughts on this potential move into a more regulatory approach to ESG and how ESG disclosures might happen, particularly in the climate space, and what that might mean for the consequences for governance, right? Because I will just say up front, I think that it could potentially go in a couple of different ways, right? You could see sort of a very reactive, like, oh my God, that means we now need a special committee that's really devoted to thinking about these very challenging things. But it may also, and I would argue it should, lead to a more reflective approach similar to what you are advocating for in your paper, where companies are really being more thoughtful about the various business and strategy risks that are going to arise due to climate and how those permeate through the business and what that means for management and supervision. So just very briefly for background for our audience, the SEC issued a proposed rule on climate disclosures on Monday. It is open for comment until either May 20th or 30 days after it is published in the Federal Register, whichever is later. The rule is functionally going to propose to modify both Regulation SK and Regulation SX. So that means both qualitative disclosures about climate risks and potentially notes to financials about your climate risks. In terms of governance, the rule is based on the Task Force for Climate-Related Financial Disclosures, but it's looking for a number of very granular things. Among them, how your board members and committees of the board engage in climate oversight, who on the board has expertise in climate risk, how the board considers climate risks and how they impact strategy, and whether and how the board sets climate targets or goals. There are additionally a number of enumerated requirements for management oversight of climate that are not as granular as the board ones. The rule would also look to have Scope 1 and Scope 2 greenhouse gas emissions, so that is direct emissions from your activities, right? If you are an airline and you fly airplanes, the emissions coming out of the plane when you fly them, and indirect emissions from energy consumption. So the power that's going to keep all our laptops running so we can be on this Zoom. And then for certain companies, it will also require the disclosure of Scope 3 emissions. So that would be emissions resulting from your supply chain, both upstream. So if I'm a power plant and I'm buying natural gas, all the methane that may have been released when the gas was being produced, and downstream, right? If I am a car manufacturer, the emissions that come from me selling the cars to people and then putting gasoline in those cars and driving them around will be reportable for some companies. And those emission requirements are going to be subject to assurance for Scope 1 and Scope 2, and those will be subject to the Commission's existing disclosure controls and procedures. So we have a whole bunch of stuff that as the authors have rightly noted, has often been done in silos that don't look a lot like our traditional governance silos, that all of a sudden is getting swept into securities reporting if this rule is finalized as proposed. And I think that raises a number of really fundamental questions. I'm sure I'm not the only person on this phone who has spent most of their week on the phone with panicked clients about this. And there are just a couple of bigger picture things that I really wanted to raise here. The first is I was really intrigued by the paper's suggestion that we need another E in ESG, right? I am a climate person by training, going back a very long way, but I think we have been living in an era where climate, while an incredibly significant societal issue that we need to address, has in many ways swallowed the rest of ESG, right? And you see that even a little bit in this proposal, right? This is a proposal about climate change, and then kind of at the back, it's like, oh, hey, but if you have metrics around water, we think maybe those are disclosable here too. And I think that has some important consequences for how we think about governing this suite of risks that have traditionally been financial but emerge into financial significance. And I'd be very interested to hear from the authors their thoughts on essentially whether a rule like this puts way too much of a thumb on the scale towards one ESG issue that is certainly strategically important for some issuers, but is not going to be the most significant one for all of them. And particularly in light of, I think, if you compare this proposal to the way that, for example, the Commission dealt with the human capital management rule last year, right? Implicit in how the human capital management rule came out and what this rule looks like is a bit of signaling from the Commission that right now they care a lot more about companies investing a lot more in climate. It's not clear to me that is should be the policy preference, that it's the correct policy preference, or that it's really the best approach for all companies. The other thing that I think is going to be really interesting here is this question of how do you think about how you organize yourself, right? You know, we had a lot of conversations with clients even before this rule came out, thinking about things like, well, gosh, when you go look at how the big institutional asset managers are talking about how they think about climate and the things they want to vote on, they're starting to say things like, well, if you get a climate proposal, we want to understand, do you have executive comp that's linked to climate, right? Do you, they're looking for very specific policies that when you looked at them, arguably did belong under existing core committees of the board, right? That maybe that's a comp function. And I think that one of the really interesting things coming out of this particular rule, given that all of this is going to go under securities reporting if the rule is finalized as proposed, is this question of like, have you suddenly double or triple burdened your audit committee, right? Because very traditionally, much of this work would have come through audit. But as the paper rightly points out, the folks on audit committees are typically financial experts. They're not going to be experts in greenhouse gas accounting. But, you know, I think it'll be interesting to see how corporations deal with that and how are you going to deal with the blowback from someone's got to understand that greenhouse gas data, understand how it's been audited and assured, and then bring it back over into, so what does that mean about what notes I need for my financials? And I know I have just 2 minutes here, so I'll give you all a very specific example of this where I think it's a challenge. So I work with a lot of companies who have long-lived assets. And one of the things they need to report in their financials is their asset retirement obligations. And starting about 1.5 years ago, because I'm a physical climate risk person at heart, I started saying to my clients, hey gosh, you know, when you estimate your ARO, do you think about whether the refinery that's in there is going to potentially go underwater due to sea level rise at the end of its life? Because I'm looking at the sea level rise projections for where it is. I'm looking at your useful life projections, and these two things do not match up to me. So have you thought about whether you need a piece in that probabilistic expectation of what it's going to cost a third party to remediate the site, which is how you calculate your asset retirement obligation, that basically accounts for maybe I can't just, you know, pave this over and assume that the contaminated soil is never going to get anywhere. And in fact, I have to prepare for this piece of land to be completely submerged and deal with the impacts that are coming from that. And none of you will be surprised to know that's the kind of thing that typically has made clients' heads explode. Because to really get at that, right, what you need is you need accountants who are expert in thinking about those kinds of economic estimations. You need somebody who knows enough about climate science to help the client make a probabilistic judgment of like, Do we think this is likely? If so, how likely? How do we weight that against the other potential outcomes? And then you need to engage the business people of the client, because for clients with certain types of long-lived assets, those AROs are a very significant part of the financial statements. And so, I think where that leaves you is that we're kind of in this brave new world where you do need a lot of different types of expertise that may need to be positioned in different ways to make this all work. And I will stop there and hand it back to Linda.
Hey, thanks so much for those thoughtful comments and for also commenting on the very recent development, because I know people have been thinking about that quite a bit this week. We are going to go to our final commenter, and that is Todd. Over to you.
Great. Thank you, Linda. And thanks, everyone. I'm Todd Phillips, Director of Financial Regulation and Corporate Governance at the Center for American Progress. I want to say before I start that all thoughts and opinions I express are my own and not of my employer. I had a list of things I wanted to say, but Margaret's talk there just made me think that I want to throw something else in. The climate rule that the SEC just proposed. I think that the reason I think the SEC proposed something about climate and not about other parts of EESG is that this is really something that investors have been clamoring for, and not just investors, but also asset managers, people who advise investors. This is just something that they really want, and the SEC is giving it to them. And I think that leads me to what I did want to talk about with regards to the piece was, I think that while the piece makes an important contribution to corporate governance literature, bringing it into Caremark, I think the practical takeaway, at least I saw, was that board directors really need to be involved with their ESG efforts. One thing that it's my sense that ESG and ESG is something that is mostly done at the management level and lower, because it is something that companies think they have to do. But it's clear that investors are clamoring for this type of information so they can make informed investing decisions. And the directors, who are the shareholders' representatives on corporations, need to do what the investors want them to do, which is to think about ESG and EESG matters. There was a 2019 letter from Business Roundtable and other companies signed by the CEOs of some of America's largest corporations, saying that they made a fundamental commitment to all of our stakeholders, including customers, employees, suppliers, communities, and shareholders. And the most significant criticism here is that it's just reducing CEOs' responsibility to shareholders, not increasing their responsibility to workers or society or anyone else. And because shareholders clearly do want this information, or do want to invest in companies with this type of activity, ESG funds total roughly $8 trillion worldwide, with inflows growing. It's clear that directors need to be taking this into account and playing a role in ensuring that their companies are taking ESG seriously, and it's not just sloganeering or greenwashing or something like that. So I think that that is one of the big takeaways there I had from the paper. A second takeaway is how the authors talk about how boards should really implement this. And I think that although it's not laid out this way, the paper does provide a very good rundown of the steps that directors should take to ensure that they and boards as a whole can play a role in companies' ESG efforts. Rather than audit committees, you need to have the entire board take into account. If you have just an audit committee that deals with these things, it really seems to absolve directors who don't serve on that committee from any ESG responsibilities. It talks about how directors must identify how the company makes money, set up board committees that way, food safety, environment, examine the company's material sources of business and their impact, and examining the law and why the law is set up in a particular way, which stakeholders the law is intended to help. Directors should use third-party criteria, protocols, frameworks, other standards, and determine how they're going to measure their ESG efforts. As the old adage goes, you get what you measure, and if directors are to use their business judgment, either relying on third-party standards or frameworks or ones they created on their own, directors need to figure out what to measure, and that's so important. I think that the involvement of the Caremark case here it explains that companies should already be collecting much of this information so that their directors can make informed decisions, or because the law says that they have to collect it to provide it to the government. So there already is a starting point, but I think it's important for directors to really be able to, or to really do the deep thinking to figure out what they want to achieve with EESG and what data they need to collect to get there. And finally, directors and boards as a whole must determine the expertise needed to ensure that EESG is taken seriously. When I was reading this, I was really thinking about the company Theranos that became a unicorn on all sorts of promises that the company was going to develop blood testing technology with only a prick of your finger. It turns out that it was all false, and the founder, I think, was just found guilty of defrauding shareholders. And throughout, there were board directors who were saying, I had no idea that any of this was going on, because they weren't scientists. They weren't people who really understood the business and were able to really advise the company on what it was doing and understand how it was doing things. And the directors should have known that Theranos was ending up outsourcing some of their blood testing to third parties because the technology just didn't work. And so I think it's clear that directors need to have expertise relevant to make sure that the company actually achieves what it wants to achieve. In Theranos's cases, for the main business lines, but also because of ESG concerns. So to conclude, I would just say, my sense has largely been that ESG generally has been a check the box exercise, but because shareholders have made it clear that they want companies to be investing in ESG efforts, either because they think that it will prove profitable for the company in the future, or because they just want their investments to go to companies that are doing the right thing and treating their employees and the environment well. Directors need to take a real, if not heavy hand, but at least they need to be very involved in what companies are doing on the ESG side of things. And I'll turn it back over to Linda.
Thanks, Todd. Thanks for those really interesting points. I have a feeling our authors are eager to respond to the comments that they've heard. So I want to hand it back over to the authors to take 5 minutes or so to respond, and then we'll go to some of these great questions we have.
Thank you, Linda. Chief, do you want to start off, or?
Why don't you kick off, and then I'd like to get at a little bit of everybody's thought, but in one integrated way, pivoting off of Margaret's focus on the disclosures, because I think there's a thing. But Riley, why don't you kick off with your immediate reactions?
Sure, and I'll start off with the disclosures as well, since that's such a big topic and timely one. You know, I haven't had a chance to review the SEC's proposed rule in detail yet, so I'll just speak at a high level. I think when it comes to any securities regulation, and this is kind of going beyond the scope of our paper, but when it comes to any securities regulation, whether it's climate or anything, for disclosures to be useful to investors, they have to be comparable. Investors have to be able to use those disclosures to compare companies to companies. Otherwise, they're just not very useful. But with any sort of disclosure situation with public companies, collective action problems prevent the private or impede the private development of useful standards frequently, which is why the SEC exists in the first place. So the rationale for these disclosures exists. And that's true for climate, that's true for anything. So just at a sort of high level principle, I think the SEC's proposal makes a lot of sense. I can't speak to the specifics of this and that requirement. I don't know enough about the science, let alone the rule itself. But that would be my sort of high level response to that. You know, with respect to the human capital disclosure and sort of comparing that to the SEC's climate rule, I think the differences between these rules have more to do with the change in presidential administrations and the person makeup of the SEC than anything else. So I wouldn't put too much stock into that. Sort of addressing Jonah's distinction between SRI and ESG, which I think is a valuable one to make. I think that's important. And corporate law scholars have distinguished between sort of pluralistic stakeholderism and instrumental stakeholderism, where I think SRI is more sort of towards the pluralistic side of that, where ESG is frequently framed in instrumental terms, especially by large asset managers like BlackRock. If you look at Larry Fink's letters, they'll often frame in instrumental terms. But the reality is companies have to deal with investors because they have investors of both types, as Jonas accurately mentioned. And our framework provides one way for companies to deal with both types of concerns, because by sort of orienting your governance around legal compliance, which often overlaps with, even if it's not a perfect overlap, with the sorts of sort of social concerns that a firm like Jonas's firm might be concerned about, maybe companies can address both. I have more responses, but I'll just turn it over to the chief.
No, I agree with everything Riley said, and I want to, the term that came up in my mind, the big word was heterodox, because we're in a big word kind of thing. And what I meant by that is everybody was stressing things, and I like, Jonas, I agree with you that different investors look at it differently. And by the way, there are people who look at ESG, I don't want to say, they're talking about double ESG, which may be the easier way to say it. Vote on that, gang, on the poll, double ESG or whatever, is they're talking about it because it's the current thing to talk about. And what we're saying is there's one thing you can't be in this country and succeed is a for-profit company that doesn't make profits. And so one of the things we're actually saying fundamentally is, Jonas, you got to be a company that navigates your input, other kinds of investors' input, people who don't care about this stuff. By the way, take a look again at WESG activism, and if they were the same people pushing managed to the market and outsourcing and regulatory shortcuts, you just wonder when what road were they on when they were converted to this new thing? And are they targeting people, Jonas, because they've fallen down on double ESG? Or are they targeting them because they've had a slip in TSR and they're using double ESG? And here's the way of thinking about it. We gave a larger thing, Todd, about, I think your points are well taken. In a companion piece that I did with Kirby, we talk about workforce and we talk about the value of turning the compensation committee into a workforce committee and having a board level way of situating executive pay within the overall workforce, dealing within contracted workers. But I'm to blame in many ways for the median CEO disclosure thing, because I wrote an article about labor and corporate governance in 2006, and my friend Damon Silver from the AFL, we got that into Dodd-Frank. And you know what the SEC has never done? They've never given life to it. And in the UK they have. And one of the things, right, Riley and Kirby and I talk about our paper is quartile disclosure. And Kirby and Riley's point about comparability, which is what's the top quartile of the workforce look like? What do they get paid? What are the jobs? What are the contractors at that level? What's the DEI composition? Go to the next quartile, whatever. All of a sudden you bring to life in a real way these things. And again, we focused out on contracted workers. But the whole point about risks, and I want to get back to my friend at Vincent Elkins, which is a great firm, and one of my favorite former students is your partner, is I'm sorry, but if you're Bluebell ice cream, your key risk to your stakeholders is your ice cream is not safe and that it's not fit for purpose. If you're Boeing, if your planes don't fly. And I thought the point about environment is what I've been always saying too. If you pollute the water in a community and they can't drink the water, is that a subordinate environmental risk to climate? And I think in terms of how we're thinking about it, and I would say Riley and I have also with Kirby done work in the corporate political spending space and lobbying. And Jonas, to your part about virtue signaling, one of the things about signaling, I think what Jonas was saying, is signaling generates its own accountability because it puts you out there and then you can measure. But we have papers as well on these things. And I think in terms of thinking about the environmental thing, I'd say there's environment, is take a look at the paper on workforce and then apply it to how you're thinking about particular companies. And we're giving, right, Riley, a way of thinking about this that's focused on this, Jonas. This is the one thing that I think we would like to see heterodox not be about. We need our market economy companies to make money the right way. They do have to be profitable, but the right way is making money net of externalities. If you don't externalize your harm to your workers or your consumers or your environment and to the communities in which you do business, that is what is going to maximize the productivity and quality of the American economy. It is going to maximize the economic and well-being of all investors because our portfolio includes the taxes we pay. And that also includes things like shifting, frankly, the more risky you make companies and you just shift value to equity holders away from debt holders. Well, guess what? Most investors are prudently invested in debt securities. Most, except for the top percent, most of it we get to save for retirement and invest is attributable to our job. So thinking about that and organizing our corporate governance system, right, Riley, about making money the right way is important, but this is complex. And to the SEC proposal, I'll just give you a couple quick concerns. I'm very concerned about the failure to deal with the public-private divide. It will not improve the climate to take high cash flow producing businesses and simply force them to go private and to avoid the hoo-ha. That will not help anything. The SEC has facilitated through exemptions the growth of huge private companies, and there ought to be a level playing field. And I am pushing Congress to do this, and I propose that $1 billion or more in revenues, whether you're public or private, you actually have to file the same double ESG things. They could do a form double ESG. The point about companies focusing on what's most salient applies to this rule. I think it would be a lot better, to be honest, if we picked 35% of the industries that were high salience and phase it in by industry. I think it is really silly to have scope 3. The so-called break on scope 3 is by size of issuer, not by industry. You know, by covering 30% of the industries well in climate and focusing on education and implementation and not enforcement in the first wave, you can probably have 90% of the impact that you want. By taking, I'll pick a company that I think has pretty good double ESG values, at least I perceive it to. 2 companies, JP Morgan, really good employer in our state, pays people well, involved in charities. Salesforce. We really want them worried about scope 3 emissions? I'm not saying they don't have double ESG concerns, but is that really where we want to focus it? And are we going to make this a private right of action where plaintiffs' lawyers can play games with this? Because when you do choose, and this is when the SEC chooses to focus on something having to be disclosed, it does subordinate other things. And they are choosing, Todd, and I'm a Democrat, and Joe Biden's a hero of mine, but workforce should go forward with climate, not in isolation. And I could come up with sensible metrics around workforce very easily that could be implemented by business much more immediately and with less controversy. And the other thing we better admit is Sometimes you need the legitimacy of congressional action. And the double materiality question is being grappled with in other parts of the world. And the reason we're talking about climate is not just because of equity investors. And if we allow it to be driven just by them, it'll be a perversion of public policy. And that's true for other environmental and workforce issues. And so I'm a fan of Orwell. Orwell was not. Orwell was a straightforward, candid person. And I think what we're saying is there has to be a real look at what companies can actually do and what's the viable way of doing it. And we're a long way from that. But this power, I think we're trying to give you a way of thinking in a business-like way that would help these companies more effectively get to where we want along. But I think there also has to be constructive feedback from the environmental community to the SEC that if you don't make this practical for companies, if you make companies do stupid things when they actually have other risks that are more important, and you don't focus on the sectors that are key first, help them. Focus on help them, not beating them up. Nobody knows exactly how to do scope 3, even as to the most salient industry. So what are you supposed to do if you're a bank? When companies are the sum total environmentally of just having their individual employees all together at work, then frankly, that calls out for carbon pricing, other government action as being more of the focus. So I worry, Jonas, to be honest, that for investors, by being very diffuse, you're actually, for values-driven investors like you're not going to get as far as if you encourage the SEC to actually focus on where it matters, and not to forget that for other companies, there are equally compelling social considerations that they should be addressing, and that if you force them down this path, it may not be the best allocation of social resources. So I think I went one minute over.
This is fascinating. And I want to get to student question, audience question, but I have a feeling my co-host, Mike Vandenberg, is aching to make a comment. So
I am. I was on, I love this paper. I pushed for it internally. I was with you all until that last soliloquy from the chief, as Riley says, and there we depart. And I understand where you're coming from, but I really do think a couple of things. Number one, if anybody on this call or anyone you know thinks that climate change isn't a dominant issue, even for companies that are selling ice cream, please contact me and let me set you up with a physicist who's the co-author on my book, which is called Beyond Politics, because climate change is going to affect us for 500 generations. And so if you care about your employees, the number one thing you can do is avoid catastrophic climate change. Number one. If you care about environmental justice, if you're on the left, number one thing you can do to help the most disadvantaged people today is to avoid the 500 generations of their offspring from suffering from catastrophic climate change. If you have any doubt about that, please contact me. We'll set up a workshop. What we do typically in my classes at Vanderbilt is we bring out all the best skeptics ideas. I have all the students go get them. We put them up on the board and we have as long a discussion as we need with a physicist to walk through what's happening. So I'm with you completely on a lot of the pragmatic parts of this. I was a partner at Latham & Watkins. I've represented investment banks. I've done hundreds of disclosures. So I'm not sort of a green advocate, but I think we are in a different world. Alan Palmer has a piece called Capitalism, Heal Thyself, where he basically says there was a transition that occurred about 2012 from the SRI front to the ESG front. And that's the way I look at a lot of this, that a lot of us are functioning based on the literature that we were exposed to before about a decade ago. And I see this as being very different. As to JP Morgan, they definitely ought to be able to and be required to disclose their scope 3 emissions. It is calculable. It's not that hard. I just wrote a paper on a lot of that. And why should they be required to? Because it is in their interest in the long run. Because we have a dysfunctional government. Should we have a carbon tax? Absolutely. I worked on a carbon tax as the EPA chief of staff from 1993 to 1995. Have we gotten a carbon tax? No. Have we had a major pollution control statute in the last 30 years? No, we have not. So sitting around waiting for a perfect solution, I think, is a mistake for companies, which makes me wonder whether we should engage a little bit as a group with the notion of common owner or universal owner theory. I'd be really interested in the reactions of everybody on the call. To John Coffey's written about this, Madison Condon and others. What do you think about that? Is that a
Michael, I wasn't smart enough to write about it as a universal owner. I've been writing about it the entire century.
I love your work. I really do, which is one reason.
What I mean is when I say focusing on growth net of externalities.
Right. That's what you're
That's
saying.
exactly what I mean. And my only point, I believe unscientifically that billions of people spewing carbon and methane into the air over 100 years, I believe unscientifically that is likely to have a huge impact and has had a huge impact on our climate. So I don't underestimate the change. I want to address it. What I'm saying, Michael, is in terms of phasing it, sometimes the more that there are companies and industries where you can uniquely focus on them and create a model and have the most impact, it may make sense to start there. The more companies look like, frankly, the sum total of us as individuals just at work, it may be that we want to not burden everybody, but do something well. I believe in big government, honestly, but smart big government, and diffuse, poorly thought out public policy that will get challenged if we do it that way by members of the business community. Because as you know, Michael, part of why we got none of these statutes is the business community lobbying and engaging in their thing. And that's where I'm with you on this, Jonas. Smoke them out and then follow the money. And I'd love to see investors ask more questions about where the money goes and whether the money is, whether the woke talk is matched by, the money trail or not. But so, Michael, it's more a difference of approach than a belief. I believe it is existential. I am not denying it in any way.
So let me raise one last quick question, if I can, to keep the spot. So I think we're very closely aligned on that. But I filed some comments with the SEC. I have a paper coming out any day now, which suggests that when I look at the way the SEC conceptualizes what the risks of climate change are, and we tend to talk about risks, but opportunities are things investors care about too. It's odd that we don't talk more about that. But the idea is physical risks on the one hand, your docks will go underwater, and the other is transition risks. And my concern is that much of the real risks that companies are facing are private governance risks. It is that your supply chain, I have a paper that's about to come out that says that 80% of the largest firms in 7 large global sectors are imposing environmental requirements through supply chains right now. But that's not a regulatory risk, which is the way the SEC, I think, conceives of a transition risk. And it's not a pure market risk. It's something in between. And I think all of you all, one of the things I love about this paper and all the commentary is you all get that, you're working with that every day. But if you actually look at the 2010 SEC guidance, and I haven't fully gotten through the hundreds of pages of the new one, but I don't see that conceptualization of the risk being captured earlier. Maybe Maggie, you've really gone through it. Maybe you see it more coming out in this version. I tried to get them through comments to do more of that, but I get a sense that we're all still functioning in an old sort of pure market or pure government regulatory area, but we're in a different zone now.
Yeah, I think, Mike, just to respond specifically on the issue of the proposal, I think that you're right in a lot of ways. I think that there is a bit of a sense of if we push more on better governance disclosure and more granularity about how you spot risks, that maybe we will, as an ancillary benefit of that, get some of these other disclosures. But I think that the private governance element of how this all happens is really where it's going to be in a lot of ways for corporations, right? That even with just a proposal, we are already, seeing lots of companies asking a lot of hard questions about how do I shape my conduct or report on my conduct so that when this rule is effective as to me, I can comply with it. And I think to the good point that was raised about private companies, right? Some private companies are going to say, oh, this doesn't apply to me, but some are going to say, I might want to sell myself someday. I might want to IPO, and how do I think about that? Or I might be the upstream oil and gas supplier to somebody who is subject to this rule. Or maybe I want JP Morgan to underwrite a bond for me, and they're going to be subject to this, and they're going to need to then report what they've done in their underwriting as part of their Scope 3 emissions. And so I think the private governance part is really fundamental and is perhaps not coming through as clearly in what the commission has proposed. And I don't know if that's because of a lack of appreciation for it or just because that's a really hard thing to get at in this kind of rule.
But again, Maggie, though, there's always going to be companies, I'm sorry, but there are companies that make money the wrong way throughout history, and that's not going to change. And there needs to be a level playing field. And all I'm saying is by not addressing the rise of private companies, the SEC is just going to imbalance it even more. You have to address it. And most of those companies use SEC exemptions to raise capital. The other point I think we make, I thought Mike made a great point about climate is Ukraine and Russia. Had we focused on genuine, sensible energy independence and addressing clean energy 20 years or 25 years ago, as we should have, we'd be in a much better position. And now we find ourselves in the confounding place of using dirty energy and having an argument for dirty energy because of national security, when it's actually the opposite. And I thought Michael's point also about jobs and opportunity for the American and for the OECD nations through innovation is something we do. But here's the point about businesses. Where are they on President Biden's effort to finish the climate change investment package? I blame my own party for $3.5 trillion of diffuse nonsense. If you called Build Back Better the infrastructure bill, that makes a lot more sense to the American people. And if you do the core part of climate, that's still left, that's an adjunct to that. But where are the businesses that we're talking about, Maggie and Jonas and all this, and Todd? Where are they on that? Because don't tell me about your disclosures if you're not going to support the process. And it takes time. I mean, there was a hydrofluorocarbon ban done during the Trump administration. And it's because of our senior senator in Delaware, who's a Democrat who worked his butt off like an old time senator to get, and he gave credit to crazy people to get it passed. But he had the Environmental Defense Fund and the BRT do it. But it takes time. But business could get the Biden package done if they use their voice. And frankly, where are they? And how do investors hold them accountable? I think that's a key thing. And that's why it's a cycle of disclosure as well, where I think, Jonas, you're entitled to know all along the dimensions of corporate impact, what they're doing and whether it really aligns with what they're saying. Because I don't hear a drumbeat from K Street going to finish the climate change package. And even frankly saying to some people in my party, yes, we understand the need for more childcare. That was kind of put on the table late in 2020, and you didn't really read the primary results. This climate thing is really important. It really does relate to jobs. And by the way, Joe Manchin might get it if you put another $100 billion into the climate with a transitional thing for the industries, and it focused on the parts of the country that generate oil, and there was a specific focus on the workers and communities. You know, that's the kind of thing where I'd love to see the business community, instead of putting out another sustainability report, have their own march on Washington. This should not be a partisan issue. It's good for the economy, but that's real stuff. And this system has to deal with that.
Yeah.
Jonas or Todd, do you want to jump in? Because we're going to run out of time. I want to make sure you have a chance to engage.
Yeah, I'd like to jump in and say, you know, I agree with everything Chief Justice Strine is saying. I think we're facing an issue here in law, in that, you know, Congress is not going to enact new regulatory statutes anytime soon. And I think that to the extent the agencies want to work on these issues, to the extent that investors are calling for climate disclosures, the SEC has to work within its existing statutory framework to get there. And I think that this climate disclosure rule is one thing that will help us get there. I think that there are a lot of other things on the SEC's unified agenda. There is at least one proposed rulemaking, if not more, talking about closing private market loopholes. There are just a lot of things here that we're talking about, and I think it's a process that just has to be worked into the Securities Act and the Securities Exchange Act. I mean, the fact is that there are people who are on the other side of this rule who are claiming that the SEC is taking up the mantle of climate regulation and is trying to declare, you know, what companies have to or cannot do regarding climate emissions. And one, I mean, not only is that not what the SEC is doing here, but it's that side trying to take down this rule that really is about what investors want and need and is core to the legal mandate that the SEC created in the 30s. So I think that there are just a lot of issues here with double ESG, and you know, to the extent we can push Congress to enact new statutes, great. But beyond that, regulators need to work within their existing authority, and I think they're doing what they can do with limited resources, and it takes, I think, folks like all of us trying to push Gary Gensler to move the SEC in a quicker direction on a lot of the issues that we care about.
Something I would just say is that if I were the SEC chief of staff right now, what I would be doing is, and Maggie, putting the pedal to the metal on getting this thing out the door, because the longer it lasts, I think the more opposition builds, as well as that, you can expect appropriations riders down the road. And I think it'll be fascinating to see when this finally gets to the Supremes, if it does, whether the major questions doctrine eats this alive like it will, the Clean Air Act Section 111 regulations. I think there's a lot of risk out there, which is one reason why I keep coming back to the idea that, again, if I'm at JP Morgan right now, even if this rule goes away, CDP has requirements, there are lots of pressure you're getting from shareholders, so there's a whole private set of things that are going to continue right now, even if this rule doesn't succeed, which is a reason why I think we have to make sure we don't put all of our eggs in assuming it's going to be public regulatory options or not. Not that I don't wish we would have them.
Jonas, did you want to say one last thing? We're basically out of time.
I'll just make one really quick comment. I appreciate this conversation, and a lot of what we've been talking about here, I think, is really sort of about power and where the power resides and how the power is expressed. One thing, and maybe this sort of pulls a lot of it together, one of the things that I really liked about the paper and that we haven't really gotten into here is the human element, in the sense of what companies are doing right now is not only motivated by the regulatory environment, not only defined by the physical risks that are happening, but their employees. The generation of employees that they are competitive for right now is incredibly demanding. And one of the things that this paper does that I think is really important is it talks about the role of reputation. It talks about the role of embarrassment and shame for CEOs and managers and boards of directors. And that human element within the companies, I think, is a really important driver of a lot of what we're talking about right now that we probably haven't touched on. And I just sort of wanted to pin up there.
Yeah. Okay, we're basically out of time, and I'm sorry we didn't get to audience questions. I just felt like this is probably one of the first really robust conversations about these recent developments, and just an exceptional panel. I'm going to offer on your behalf that if somebody put a question in the question box and they really would like to get an answer to that question, just put it in there again, and I will direct it, and hopefully offline some of our panelists will be willing to respond. So thank you for a wonderful discussion. We're going to take basically a 10-minute break. Once again, we apologize. You will be able to hear us doing the tech check, but we will reconvene in about 10 minutes to talk about our third and last panel on rethinking grid governance for the climate change era. And again, thank you so much for a fantastic discussion.
Yes, thank you. That was a terrific discussion. Great paper.
Thank you, everybody. Thank you so much.
All right. Well, welcome back, everyone, to our third and last panel of the day. Before we start our panel, I want to introduce our new Environmental Law Institute president, Jordan Diamond, who has joined us since our last ELPAR conference. And as many of you know, Scott Fulton has moved to president emeritus, so he'll fortunately still be working with us. But we're so excited to have Jordan. She joins ELI from UC Berkeley, where she was the executive director of the Center for Law, Energy, and Environment. And she is also a former ELI attorney, so she's come full circle, and we're just so excited to have her back. And I just wanted to hand it over to her for just a minute to say welcome and let you say a few words before we jump into the panel.
Thank you, Linda. It's wonderful to be here, and of course, it's nice to virtually meet all the Vanderbilt students who are doing such a great job of introducing the panels today, and did such a tremendous job from the outset of picking these articles with our course instructors and, of course, with our terrific ELPAR advisory committee. In the interest of time, as Linda said, I will keep this extremely brief. I simply wanted to take a moment to personally quickly welcome everybody to the final panel session of the day, and express my sincere hope that we are back together in person next year. It's a particular joy to welcome everyone to this panel, which is focused on such an incredibly important topic and really the cutting edge of where we need to move forward. Stepping back, I also wanted to offer one additional note. Although, and this is on kind of the conference as a whole, although I have only recently returned to ELI after an 8-year hiatus at UC Berkeley, I have kept track of ELPAR over the years. And that's because of the immense value I place on bringing ideas from the academy to policymakers and to practitioners. Because while we may wish it to be otherwise, we do in fact know that busy lawyers don't always have time to peruse law journals. Although I feel traitorous saying that because I met Casey Roberts when she was my editor-in-chief at the law journal at UC Berkeley. So Casey, that was not true when we were working together, obviously. But in general, ELPAR has been such an outstanding 14-year partnership with Vanderbilt Law School, which we hope will continue far into the future. So with that, I will stop hogging the microphone and simply extend my thanks to all of you for joining us today and look forward to the conversation. Back to you, Linda.
Thanks so much.
We really appreciate your effort, Jordan. You're glad you're joining us.
Thank you.
Well, I'm going to hand it over now to third-year law student Joe Hendricks to introduce our fantastic panel.
Thanks, Professor. My name is Joe Hendricks. I'm a 3L at Vanderbilt Law School and an articles editor for ELPAR. I'm here to introduce our third article, Rethinking Grid Governance for the Climate Change Era by Professor Shelley Welton. Professor Welton is an associate professor at the University of South Carolina School of Law and the incoming Presidential Distinguished Professor of Law and Energy Policy at the University of Pennsylvania, beginning summer of 2022. Prior to academia, she was the Deputy Director of Columbia Law School's Sabin Center on Climate Change Law. We also have 3 panelists with us today. First is Casey Roberts. In her position as a senior attorney at the Sierra Club, Casey advocates before state public utility regulators and at FERC for policies that protect consumers and allow full and fair competition by renewable energy, energy storage, and demand-side resources. Before she joined Sierra Club in 2011, Casey was a fellow at the Natural Resources Defense Council and at Altshuler Berzin, LLP. Casey received her BA from Rice University in Biology and Public Policy, and her JD from the University of California, Berkeley, where she was the editor-in-chief of Ecology Law Quarterly. Following law school, she clerked for Judge James Parker in the District of New Mexico and Judge Diana Murphy on the 8th Circuit Court of Appeals. Our second panelist is Tom Hossenbohler. Tom is a partner with Coefficient, a mission-based strategic consultancy focused on advancing public policy and market solutions in the energy and environmental sectors in Washington, D.C. From 2013 to 2017, he served as the Chief Counsel for Energy and Environment at the U.S. House Committee on Energy and Commerce. Before his role in the U.S. House, he worked in the private sector as the Vice President of Policy Development and Legislative Affairs for America's Natural Gas Alliance. Tom's earlier experience was in the Senate as counsel for the Committee on Environment and Public Works. A native of New Orleans, Tom received both his undergraduate and JD degrees from Louisiana State University. Our final panelist is Rebecca Tepper. As the chief of the Energy and Environment Bureau in the Massachusetts Attorney General's Office, Rebecca serves as the Attorney General's chief advisor on energy and environmental law and policy. Prior to joining the Attorney General's office, Rebecca was the general counsel to the Massachusetts Department of Public Utilities, DPU. Prior to the DPU, Rebecca served as the director of the Massachusetts Energy Facilities Siting Board. Before joining the state in 2009, Rebecca had 15 years of experience in the private sector, representing developers throughout the Northeast in siting, permitting, financing, and contracting of renewable, distributed generation, and conventional energy facilities. Rebecca is a magna cum laude graduate of Boston University Law School and received her Bachelor of Arts from the University of Wisconsin-Madison. I'll now hand it back to Professor Bragan.
Great, thank you, Joe. An incredible panel, and we're just gonna jump right in and hand it over to Professor Welton. Shelley, you wanna take about 15 minutes and tell everyone about your article?
Great. I want to just start by echoing lots of the thanks to ELI and Vanderbilt, to the students who I know work so hard to pull all this off. And to my commentators, thank you so much, Casey and Rebecca and Tom, for taking the time to engage this article and really talk about some of its ideas. It means a lot. So I thought I'd start my presentation with just a little bit of good climate news, which always we are in need of. So let's see if I can get this to advance. I can't make it advance. There we go. Okay. Somebody's making it advance. So here's the good news. 1 in 3 Americans now live in a city or a state that has either committed to or achieved 100% clean electricity. That is not a small number. That's a number from the end of 2019 from a study out of UCLA's Luskin Center. If you look at a timeline, which maybe somebody can put up for me.
Shelly, I'm happy to try again, or I can do it here. Try one more time.
Okay. I got nothing still.
Okay.
All right. Heather, it's all yours.
There we go. Thank you so much. Okay, if you look at a timeline, this is a trend that's been significantly accelerating. It accelerated a lot even during the Trump administration. And I'm really thrilled by these numbers because I think it aligns with a lot of my past work and a lot of theories suggesting that democratic engagement in energy policy may actually ultimately help build a more durable national movement in support of robust action on climate change. And under this growing democratic support that we see here, you see companies that are wise to the fact that at least publicly, they need to display some recognition and acceptance of climate change. You even have the big Southern utilities now making net zero pledges. But at the same time, what I argue in this paper is that they're shunting some of their resistance to more technocratic, less scrutinized corners of energy policy, including, as I'm going to discuss today, grid governance. So Heather, can you hit animate twice, please? Yes, great. So the main argument that I want to make today is that I want us all to be paying a lot more attention to this sort of hyper-technical world of grid governance, because in many regions, as I argue in this piece, privatized grid governance is emerging as a hurdle to hard-earned democratic progress on climate change. And so I was moved to write this piece by this kind of sense of mounting frustration that there aren't adequate mechanisms of accountability to make private grid governors respect democratically determined climate change policies. And so I'll build through the presentation to a series of suggestions about how we might increase the accountability of grid governance to the public interest. First, though, I have 2 pieces of background to cover. And the first is how the grid is governed. The second is why the electricity system matters so much for climate change. Okay, next slide. So in terms of how the grid is governed, there's basically 3 parts to the electricity system that most people that feel the need to tune in for this probably already know about. There's generation, making the electricity, transmission, moving it, and distribution, delivering it from utilities to customers. And in the US, the key law that establishes authority over the electricity system is the Federal Power Act of 1935. It grants states control over generation and sales and delivery to end-use customers. Heather, will you animate twice to make the green areas come up? Yep, so these areas, state control. And then it grants federal control to FERC, the Federal Energy Regulatory Commission, over interstate sales and transmission. So basically the part that Heather's going to make blue right now. Yeah. And FERC's job in particular is to ensure that all utilities charge just and reasonable rates for the services that it regulates. Now, traditionally, all of these grid functions were performed by these individual vertically integrated utilities that owned the entire system in a single monopoly service territory. But as part of the deregulatory initiatives of the late 20th century, ownership of these resources began to be split apart, and many more sales started to occur between utilities. That created the possibility for lots more price discrimination. Basically, utilities would charge other people more to access their lines than they would charge themselves. And so FERC increasingly intervened to ensure non-discriminatory access to the grid. And in the end, I'm going to make a long story short and just say, in 2000, FERC asked all utilities to either create or join what are called regional transmission organizations, or RTOs, to run the grid. Next slide, please. So most regions did what FERC asked. You can see here a map of the RTOs that have formed. A few regions took a big pass on FERC's idea, those areas that are in white. There's some interesting comparisons to make between the areas that didn't join an RTO at all and those that did. I have a different project that's looking at some of those issues, but for now, I really want to focus on the 2/3 of the country as measured by population that ended up with this RTO structure. I want to focus here primarily because pretty much everyone agrees that if we're going to achieve decarbonization, we need more regional grid cooperation. And in regions that did create these RTOs, these organizations perform several really important functions. They manage the transmission grid, which means they set rules to make sure that everyone has fair access, gets compensated appropriately, and they plan and they pay for new transmission infrastructure. And they also run a series of markets, including most centrally markets for electricity, where generators bid in and utilities buy whatever they need to serve their customers. Which means that these RTOs also have to establish rules and policies regarding how energy gets priced and regarding eligibility to participate in these markets. So how do they set these rules? There are a lot of regional divergences here that I'm not going to go into. Uniquely, California created its RTO, which is called CAISO, as functionally like a state agency. So there's no members, there's a state-appointed board, and they make their rules through pretty classic notice and comment rulemaking. The rest of the RTOs, though, are far more privatized in their structure. So I argue that they have many of the hallmarks of new governance or reinventing government theory that was in vogue in the late 90s when these entities came into being. These are not-for-profit, voluntary membership clubs that utilities can choose to join if they want to. They're overseen by a board of directors that can't have any financial interests in any members, although they typically are industry insiders. And the rules are established primarily through membership voting processes. So I just want to give you a flavor of what this looks like in one RTO, PJM, which is the largest RTO. Heather, will you animate maybe twice? Yeah. They use this process in PJM called weighted sectoral voting. So each of these 5 sectors gets 20% of the vote, and a proposal has to get a supermajority in order to make it through to the board. Heather, will you animate, please? And then in all regions, for some issues, the board can independently approve. For some issues, they actually have to get through the membership voting process. So I'll just say, I can see why RTOs made a fair amount of sense to FERC in the late 1990s. The industry was kind of chugging along. There were limited political pressures to change sources of electricity. And they seemed like they just needed some rules for reciprocal fair dealing about how to manage the grid. However, in the decades since, there's emerged a definite clash between this privatized model of grid governance and the climate change challenge. So that brings me to a little bit of background on decarbonization and the grid. Next slide. So I want to just talk for a minute about why the grid matters so much for climate change. We're at a critical juncture for responding to this problem. If we're going to have a plausible shot at keeping warming to non-catastrophic levels, which is still going to pretend catastrophe for plenty of people, leading scientists suggest that over the next 15 years or so, we need to take the electricity system, Heather, will you animate, please, from over 60% fossil fuels to 0% fossil fuels, at least if we don't have any substantial advances in carbon capture and storage. And that's a fact you see reflected in all of those state 100% clean energy mandates. States understand what we need to be doing here. Some states do. At the same time, the system needs to integrate a host of new technologies on what's traditionally been thought of as the demand side of the system. So Heather, can you hit 4 times, please? So we need to integrate resources like energy efficiency and demand response, lowering total demand, like small-scale renewable energy, most notably rooftop solar, battery storage technologies, which are really increasing substantially their presence on the grid, and electric vehicles. These electric vehicles are particularly important and challenging because pretty much everyone agrees that one of the key ways we're going to clean up the transportation sector is to move to electric vehicles, which means that if everyone's plugging their cars in, at the same time that we take this system down to 0% dirty energy, we have to basically, most people think, at least double the size of the grid. So it's a huge challenge that lies ahead and critically important for basically decarbonizing across the economy. So my goal in this project was to forge this link between grid governance and climate change. A lot of scholars are thinking hard about this decarbonization challenge, but there just hasn't been a lot of discussion to date linking decarbonization as a substantive challenge to the governance of the energy system, even though pretty much everyone agrees that RTOs are going to have to play a key role in facilitating this transition. And I should just note that as a theoretical matter, there really shouldn't be any clash here. RTOs describe themselves as policy takers in charge of making their markets run in light of whatever policy priorities state and federal regulators adopt. But what I suggest in the paper is that's not really how things are going in the era of climate change. So in my project, I set out to trace the many ways in which RTOs as grid governors are writing rules that disfavor clean energy and favor traditional resources. One set of challenges that I call the heel dragging challenges really involve a lot of the new resources that are cropping up on that traditional demand side of the system. Here, RTOs need to amend their market rules to allow these resources that have characteristics that look pretty different from, say, like a large coal plant to compete in their markets. But they've been extremely slow to do so, even though a lot of evidence suggests that they would save consumers a considerable amount of money by moving on these issues. And that's because these technologies often threaten the bottom line of incumbent transmission and generation resources who make their money off of building more supply-side infrastructure. Now, on the supply side of the equation, many incumbent generators within RTOs are none too pleased that states are mandating the aggressive adoption of renewable energy. I think I have animation here too. Nope, just kidding, I don't. Okay, so states are mandating the aggressive adoption of clean energy, which of course by adding supply is going to drive down prices in RTO markets. This is a particular threat to companies with a substantial amount of natural gas resources who've made pretty recent and long-lived infrastructure investments that they're afraid aren't going to pay off in the long run if renewables continue their pretty dramatic ascent. So in the past few years, this has become a particular problem in two Eastern RTOs. Heather, will you hit animate twice, please? PJM again, and ISO New England. So in these two RTOs, incumbent suppliers pushed a series of complex rule changes, and I'm not going to go into the details of, in their markets, which essentially made it a lot harder for renewable energy that was supported by state policies to compete with fossil fuels in supply and capacity in these regions. PJM has since walked back this reform. New England still has a legacy of theirs. Now, these changes actually failed to get supermajority support in either of the region's voting processes, though they came close in both. And states in both regions pleaded with the RTO boards not to undermine their clean energy policies, but the boards filed the changes nevertheless. And FERC, under the Trump administration, accepted these revisions on misguided rationales that were basically grounded in investor confidence. The result is that private RTO governance processes succeeded in causing consumers to pay probably at least tens of millions of dollars for unneeded, polluting fossil fuel generation that states definitely did not want investors to be confident in building. Now, a lot of commentators have recognized the perversity of these reforms, not least FERC Commissioner Glick, now Chair Glick, who wrote scathing dissents from both orders. And they did also get some press coverage. So Heather, will you put up two more clicks, please? So here's two headlines. The first is the December 20th, 2019 headline from Chairman Glick. The second is from a Maryland commissioner basically saying that these reforms were messing with state sovereignty. So it's not like they didn't go unnoticed, but here's the most prominent publication that covered these in detail. Animate, please. I love Utility Dive, great trade publication, but it's not exactly mainstream media, right? So I think this is a perfect example of a reform that has major impacts on the clean energy transition happening behind the scenes in these private processes, out of the media spotlight, but with the same effect as a lot of the Trump administration's more public pronouncements about trying to save fossil fuels. So I could point to a bunch of other examples regarding transmission planning, interconnection policies, but that's enough to give you an idea of what I'm trying to trace. So as these examples help to illustrate, privatized grid governance is emerging as a threat to progress on clean energy. Whether proposals proceed or fail to proceed through RTO's sort of democratic voting process, or they get passed on by the board after having failed these processes, there's a substantial gap in democratic legitimacy and public accountability in RTO governance. Some researchers, especially outside of law, have started to sort of catalog this, and the main solution proposed to date has been to reform stakeholder processes within RTOs themselves. I think this is a totally good idea. I would love to see it happen. But what I ended up saying in the piece is that I think this is probably too anemic of a solution in the long run, right? The problem here is that private governance by incumbent industry members just doesn't really make sense in an era in which the entire sector needs to transform. So as I see it, the problem with RTOs is really one of two public-private accountability gaps. Heather, next slide, please. One between states and RTOs, and one between FERC and RTOs. So I'll just say a word about each of these and then offer a few suggestions. So states by statute have control over their generation mix, but RTOs are often not working as partners to help them exercise that control. And in part, that's because states themselves have very little voice within RTOs. Although regional state committees exist in every RTO, they typically are relegated to kind of a weak advisory role. Second accountability gap is between FERC and RTOs. So one fair argument here might be that FERC approved all of the changes that I'm complaining about. It's FERC's fault. And in part, I do think, particularly under the Trump administration, FERC sort of evolved from sort of an independent bulwark agency to something that was much more politicized. But I actually think the private structure of RTOs facilitates this kind of accountability gap across administrations. And that's because when FERC created RTOs, it was using this old statute. So it's used its old authority to regulate these as normal public utilities under the Act. And what the law tells FERC is that it has to be passive and reactive in this role, and can only force changes in practices if current practices are entirely outside the zone of reasonableness. That's a framework that looks really different from the typical way that agencies operate, right? The Chevron framework typically lets agencies pick their preferred policy solution and requires courts to defer. This is really a much more cabined role for the regulator that we've created in the current legal framework. That makes it hard for FERC to force beneficial changes, even when the agency wants to be proactive, and it gives commissioners that are sympathetic to incumbent interests a lot of cover to sort of passively and reactively accept biased rule revisions. So that brings me to a couple ideas for solutions. There's a lot of excitement about the powers that a Biden FERC might have to fight climate change. And the commission's already making some really good strides on substantive reforms in this regard. But one of the key reasons that I engaged in this project was to make the case that governance reforms, even though they're tedious and less sexy, may be a key precondition to durable, rapid progress on climate change. So I want to highlight quickly two such reforms that I see as particularly promising. The first thing I want to emphasize, though, is because renewable energy requires a more integrated grid, we cannot just unwind. We've got to figure out a way to make better RTOs. So one option that I put up here is to give states more control in RTO rulemaking. So a regional state committee could be given a more robust role in the process, such as maybe a veto point over proposals that implicate state interests, or a right to file competing proposals with FERC. Second policy option, animation, is to stop regulating RTOs as plain old vanilla utilities and recognize them as policy-making bodies, either through a statutory rewrite to give FERC more direct authority, or through FERC deciding to exercise some of its muscle and spend some political capital and declare that RTO governance as presently conceived is not producing just and reasonable rates. Finally, I'll just throw out a more radical option that I talk about in the paper, which is to consider a more thoroughly public grid, right? You could have public ownership of the grid. You could have agency control over these decisions instead of a private governance model. That would bring the system on a national level closer to the California model, which California reports has been pretty important in helping that state achieve robust decarbonization. Now, I don't think this final public solution is likely to happen, but I do think it's important to put it out there as a framing point, which is that this system really needs to be made to work for the public in the service of democratically established goals that we have for the future of the grid. So I will leave it there. Thanks, and I really look forward to your comments.
Thank you so much, Shelley. I learned a lot from your article. We had a really interesting discussion in class about it, and I just want to say you've totally raised the bar for me on the slides. That animation thing is very cool, and I am definitely going to try to do that now, probably not with as much success. I want to remind everyone that the slides will be posted on the ELI ELPAR website, and also remind everyone to send questions in now. Don't wait till the end, just put them in the question box. And I think with that, we're going to go to our first commenter. Tom, take it away.
Okay, can everybody hear me? Yes, thank you so much, Shelley and Linda. It's great to be here. One of the first things I wanted to comment on is just appreciating how very readable your article is. That's one of the main challenges for this complex topic, just getting people to want to understand and pay attention to the big picture and what's at stake here. And I think you've done that very nicely. I mean, kudos for translating the challenges and the opportunities of RTOs into something very readable and interesting. So that's just the first kind of comment. To cut right to it, I'm going to make 3 points that follow just brief introductory remarks, and then move it, and I'll be brief and to the point. And the first thing, move to the next slide there. So I'm a late appreciator of and supporter of RTOs and what they've achieved over the last 2 decades. I really, despite working on Capitol Hill for several years in my early career, it wasn't until my second stint on the Hill, when I came up as chief counsel, that I even really understood what an RTO did. And that's should be a little bit unnerving to people. Frankly, it's because this problem and this topic has been really relegated to the FERC experts, the electricity practitioners. A lot of people view it as overly cumbersome, complicated, problematic, and they just don't want to engage. And that's a problem. It's a problem because, as I think Shelley rightly points out, this matters on so many levels, and it's so vitally important to the future of climate policy, energy policy, security, resiliency, everything that we should care about as a nation. My second kind of, Congress used to care, actually, and it was before my time, but I'm sure several of you are aware, when in the late 90s and 2000s, Congress was actively debating these topics, right? You had several bills in the late 90s. You had, of course, the fallout from Enron, which kind of stopped and slowed down the rush to competition in the United States Congress and kind of froze everything where it is today. And then we started focusing as a nation on climate policy, Clean Air Act policy, environmental policy shifted away from electricity policy. And we didn't really, we lost about a decade of focus on the Hill. My second stint on the career, I did start a series of hearings that I'm very proud of, and I encourage you guys who are interested to look at, called Powering America in the House Energy and Commerce Committee. The hearings ran for 2 years, and they were, what's interesting about it is that they were done completely bipartisan. We had the Republicans and Democrats jointly set up the themes, the topics, the witnesses, and we did just a series of exploratory hearings on kind of the current status of wholesale markets and their challenges, their opportunities. One of my favorite hearings from that series was one called Consumer-Oriented Perspectives on Improving the Nation's Organized Markets. It was kind of the first, it was done in 2015, but it was the first way, and it kind of inspired my career now, where we brought together kind of the 21st century electricity customer, a big tent evolution, from consumer advocates to large industrial and tech customers, to the more active climate conscious consumer who, really wants to secure clean and increasingly localized electrons. Those active customers were just really not part of the equation 2 decades ago when RTOs were first evolving into their current space. It was set up as a platform for transmission owners and generators to trade and to dispatch in real time and increase economic efficiency, which all of those things made a ton of sense, and they were moving in that direction anyway. But now, as the electricity industry evolves, RTOs have become a topic at the state and in the regional level again, and that's in no small base it's no coincidence that it's also paralleling with the rise of this new active electricity customer. And so as part of that, I think, Shelley, your article correctly points out a lot of the flaws and a lot of the challenges and challenges the reader to think a little more comprehensively about ways to improve upon their existing structure. And that rethink really comes at a critical time and opportunity as new configurations of RTOs are actually being considered in those white regions of the country, in the Southeast and in the West. And as more engaged efforts are happening in the existing RTOs, they're kind of at a crossroads. There's been a continued release of, academic stakeholder articles about, how RTOs are being transformed and what needs to happen. And so I guess we can move to my 3 points now, which are on the next slide. They're pretty simple, but I think they kind of underpin Shelley's, bottom lines here. I think there's from incumbent operators who aren't necessarily inclined to push the envelope on technology innovation and change. I think there's been a growing resistance to keeping the RTO model as a path for this country to kind of build its platform for the future. I think most of the stakeholders, while there's some disagreement in some regions of the country still, are looking towards improving and making the RTO experience better. So if ultimately delivery of reliable, affordable, resilient, and clean are our intended outcomes, I think, Congress has spoken in the past supporting competition and wanting to continue to promote it, but I think everyone is in agreement that more must be done to get us there, and markets are far from perfect. They are a construct more than a platform for a perfection of, everybody wants to get something out of a market that's different, and hence we have a lot of, problems with how we manage this and put this together. The role of the customer really is the new wild card. Exacerbating these developments is you got technology change that outstrip the pace of regulatory and institutional adoption. The customers of the RTOs, one thing, was never really supposed to be the customers in the traditional sense. When we look at customers, meaning customers, industrial customers to a residential customer, we've done assessments of consumer advocates and other customers who don't feel like they are the customers of the RTOs. They ultimately were set up as the transmission owners. And I think that's a different paradigm that is shifting fast as this active climate conscious customer, whether you're a large tech company who wants to build on-site generation and have 24/7 clean, to a residential customer or municipality who wants to accelerate the transition to clean, and frankly, the local monopoly utility is not delivering the goods. These platforms are ways to have a functioning market that can actually speed up the process and accelerate the transition, which is why, as I think Shelley correctly says, most academic stakeholders and clean energy advocates have put their weight behind pushing towards an RTO and expanding RTOs and improving them. So, but all these forces together really have created an extremely difficult confluence of challenges to really harness, govern even the best functioning market systems. And that necessitates, no problem. That necessitates even more the final point about Congress. And, obviously I'm going to be a little biased towards Congress because most people roll their eyes and say, yeah, right, Congress is never going to do anything. I'm going to argue that Congress is ultimately the only place that can fix this problem. Like, we are in a state where, there is no real, the black boxes that were left to fill voids over the last several years because of a lack of regulatory and political will have just continued to compound on each other over the last 2 decades, to the place where, FERC doesn't have even an aggressive FERC. Chairman Glick certainly has been aggressive on several things and is supportive of markets. There needs to be a greater political will to move the needle on this. And without that, we're going to be stuck with some, next to best, solutions that are going to be kind of burbling up from the bottom up. My argument is the top down really is the only way to do this. Now, that doesn't mean we roll over the states, and that doesn't mean the states are not part of this equation. I think one of the main points is that, similar to the highway system, the states need to be part of the players here, and we must think bigger about where the status quo has left us. We're in these regional sandboxes. There's partly due to the physics of the grid. That's partly due to state versus state, regional conflicts. We have to think about how the grid, that was built in a different era, should run more like the interstate system, with the free flow of electrons across state lines and increasingly being generated behind the meter, across traditional jurisdictional boundaries, is really going to change the paradigm for the future. And that really, the only place to debate that is Congress. Congress is vested with the, often forgotten Interstate Commerce Authority that does allow for the creation of the Federal Power Act in the first place. And, and I think with the sensitivities towards states right now, there is a lot, rightfully so, there is a lot of hesitation to tackle some of these things, which is why some of the suggestions that are emerging in Congress, just to close, are very promising. The good work that we did at the committee 5 years ago hasn't been lost. In fact, there's several folks in Congress currently that want to continue this shift and move towards this solutions. Senator Markey has just recently introduced a bill that takes a comprehensive look at some of the solutions for the grid of the future. One of them, very relevant to this, and something that we've worked on, is setting up a FACA-style advisory committee, like taking these issues outside of FERC, outside of the RTOs, and developing a very comprehensive approach to think about some of these solutions and opportunities that Shelley posted in her very, good, article, ranging from technical fixes to capacity markets to, should the RTOs be completely rethought as public institutions? I mean, all of those kind of things could be on the table in that kind of setting that is not part of a current, FERC technical conference. There are some other opportunities for FERC to look at this. Order 719 is a very commonly cited order that I know Casey knows well and will probably mention, that we have been working on too. And there are some emerging efforts in the House of Representatives to get FERC to revisit that order, which was the last time that FERC took a comprehensive look at stakeholder reforms at the RTOs. So I guess in closing, my point is all is not lost. Congress is still interested, and there's a lot to think about in this, and we really do need to build more awareness and education on this topic. And I applaud the author and applaud the effort. So thanks for having me.
Tom, thanks so much for your comments and observations about how this actually may play out in practice. And I have some follow-up questions on that if we have time during the Q&A, but it did help me fondly remember the days when there was bipartisan oversight hearings and bipartisan fact-finding hearings. And I'm glad that you have some optimism about moving forward. So Casey, you are up next.
Okay, great. Thank you so much to Environmental Law Institute for inviting me to participate in this, and to the folks at the Vanderbilt Journal for their support as well. Really appreciate the opportunity. As a practitioner, it is incredibly helpful to have someone pull together all the big ideas that you've pondered before, having to shove them down to deal with the next big filing deadline. So I really excited to see Professor Welton's article. It was actually sent to me by a state legislator who I have been in some discussion with on these issues. So just to reassure folks thinking that maybe law review articles don't have an impact or get attention, this one really speaks to the moment at hand, and I think that shows. Before I get into all that, I actually want to take a moment to personally congratulate Jordan Diamond on becoming president of Environmental Law Institute. As Jordan mentioned in her intro, she and I were on the Ecology Law Quarterly board together. And that was more years ago than I would like to admit, but I remember well what an effective and fun team member Jordan was. So I know ELI is in excellent hands. So could you advance to the next slide, please? I would like to start out with a little bit of a description of Sierra Club's advocacy at regional transmission organizations. So I'm a senior attorney at Sierra Club, been there for about 10 years, working on RTOs and FERC for 5 to 6 years of that. And I think that this will just give a little bit of perspective on my comments today. So first, one of our objectives is to ensure that RTO market rules and transmission policies don't unnecessarily support fossil fuel resources or serve as barriers to clean resource entry. And in advancing that, consumer protection is always front and center. Obviously, the affordability of electric service is a significant issue in our country. And it's very important to organizations like Sierra Club and many of the others who we work with in the RTO space that decarbonization not proceed at the expense of consumers, and that the efficiency that markets can bring when they are allowed to actually be truly competitive is really significant to consumer protection. Sierra Club is also skeptical of RTOs as a forum to advance decarbonization for its own sake. And on this, I really highly recommend another of Professor Welton's articles, Electricity Markets and the Social Policy of Decarbonization, which really helpfully explores sort of RTOs versus states and other more electorally accountable entities as forums for advancing decarbonization, given the many sort of objectives and broader values that are important in those policies. So that article very accurately describes some of the questions and concerns that we have, and has really guided our approach to RTOs, taking them much more on their existing terms about market access and transmission planning, for example. Finally, I'll note that our advocacy in this space is sort of attempting to demonstrate a model of RTO influence without membership. So we are not a member of any RTO, but we do participate in stakeholder processes to varying degrees. Obviously, bandwidth is an enormous consideration there. So we have targeted engagement in stakeholder processes, and then at FERC and in the federal courts. And we work to support the efforts of sort of aligned RTO members, and also to bring in outside voices and draw attention to what's happening in these spaces in a way that we hope can influence the outcomes. And you'll see that these strategies kind of reflect some of the recommendations or hopes that I have for how we can move ahead in RTO governance. So next slide, please. So the two main points that I want to make here today are, and hopefully things we can explore in the discussion later. So first, I want to offer some more context on how FERC influences RTOs. I think here I disagree just a little bit with Professor Welton's article that FERC's authority is too limited to serve as a meaningful check on RTOs. There's a bit more to it, and I just want to add my perspective so that folks don't come away with too dim a view of FERC's authority, because I think there's maybe more than meets the eye there. Second, I completely agree with Professor Welton that consumers and states need a bigger voice in RTO governance. I also see challenges to achieving that. So in the spirit of yes and, I offer a few near-term, perhaps slightly less ambitious ideas for increasing the power of those voices in the meantime, while hopefully, as Tom says, we can eventually get Congress to act to bring about deeper reform in RTO governance and how they interact with their various regulatory authorities. So next slide, please. Thanks. So in my view, FERC's ability to shape RTO tariffs is substantial, even if under Section 205, FERC is mostly limited to a sort of yes/no answer, up/down vote on what the utility files. First, in my experience, many RTO Section 205 filings, especially on big issues, are shaped by conversations with commissioners and staff. These may be public conversations, as in a technical conference, or private ones, which frequently happen in the lead up to a filing. So I think that what the RTOs are filing under Section 205 is often the middle and not the beginning of the story. FERC has actually had influence on the utilities' thinking and how they're weighing their different member perspectives leading up to that. RTOs don't want to have their filings rejected, and will try to develop more information about issues are concerning to FERC, or what kinds of analysis FERC has indicated it might want to see, that sort of thing. So that's kind of maybe a less obvious way that FERC is able to influence what the RTOs are doing. Also, while FERC can take a deferential-like stance under Section 205 and find that a wide range of proposals are just and reasonable, it definitely doesn't have to do so. FERC rejects RTO Section 205 filings all the time, and I don't think the problem is that FERC lacks sufficient authority to keep RTOs in check simply because it can't modify those filings. Things certainly might get done more efficiently if FERC did have the authority to modify RTO filings, but I think that where FERC can, either a record is created by stakeholders or through FERC's own investigation, it, notwithstanding the sort of passive and reactive stance, it really can push back on those 205 filings, which also brings us to section 206 of the Federal Power Act, where FERC does have direct authority to make things happen. As Professor Welton notes, in her article, it can be ponderous and more legally risky for FERC to act under section 206 because it must show that the status quo is not just and reasonable, rather than simply showing it has a better idea about how to do things. I certainly agree with this, but I also don't think we should discount the authority that FERC has under section 206. The article discusses a couple of examples of FERC using this authority in recent years to open up RTO markets to energy storage, distributed energy resource aggregations. Of course, the full benefits of those orders have yet to be seen. And of course, 206 can be used for some unfortunate, at least to Sierra Club ends, such as the orders that FERC did put out in the PJM context regarding the minimum offer price rule, which we do not have to go into details of that just yet. So for better or worse, FERC has the authority to get RTOs moving in certain directions if it really wants to, and if it's careful to develop a solid record. And my final point here on this slide is that, these limitations on FERC's authority aren't unique to RTOs. And Professor Welton just talks a little bit about the evolution of RTOs from the sort of prior traditional utility model. This sort of reactive and then barriers to acting under section 206 is how FERC interacts with all utilities. And I think that the situation is actually a lot better when it comes to RTOs than these other utilities, because the stakeholder process, as flawed as it is, does force some transparency or some analysis, and at the very least gives advocates a heads up to start building a case against a utility's filing. So this improves advocates' ability to hold utilities and FERC accountable. I don't want to overstate the case here. RTO governance matters a lot. But I'll come back to this point later, because I think that even short of deep governance reform, FERC could take some actions that would significantly improve the quality and transparency of the stakeholder process. Next slide, please. The next concept I wanted to react to that comes up in Professor Welton's article is what FERC can actually do on governance. The article discusses the CAISO case, where FERC's efforts to shape the CAISO board were rebuffed by the Ninth Circuit. But there are a few other cases that are significant in my world that I wanted to bring up that I think suggest some potential paths forward. One of these is this NEPL Participants Committee case from 2019, where NEPL actually sought to change, NEPL is the governance stakeholder body for ISO New England, and they sought to change their market rules, or their membership rules, to prevent a reporter from becoming a member. And FERC rejected this, and in doing so, reiterated that it does have jurisdiction to, with respect to membership. And it said that because membership directly affects commission jurisdictional rates. A prior order that I also think is helpful relates to, this one comes out of PJM. And in this order, FERC approved a tariff filing that would grant funding, a funding mechanism for the PJM consumer advocate body known as the Consumer Advocates of PJM States, or CAPS. And here FERC said and clarified really that stakeholder input is an essential element of just and reasonable rates coming out of RTOs, and so commented quite a bit on sort of the quality of stakeholder deliberation and the stakeholder process in terms of what rates come to FERC. So, these two examples might make your imagination sort of run wild about what can be achieved. But I do think it's important to be realistic that there are practical limitations on FERC's ability to use its authority over governance in the stakeholder process. And this is because, with just a few important exceptions, RTO membership is voluntary on the part of transmission organizations. So there's only so much FERC can do to push on this without making it unattractive for transmission owners to be members of RTOs. And that's why, as Tom was suggesting, I think some congressional action on this point would be really helpful to sort of strengthen FERC's hand vis-a-vis the RTOs and governance. Right. Next slide, please. Okay, so I also think it's important to note that the political environment in which RTOs operate can moderate their pro-incumbent tendencies, which are well detailed in Professor Welton's articles, unfortunately. So first is that RTOs are very sensitive to perceptions of their fairness and independence and legitimacy. Despite the maybe most prominent articles on this PJM controversy being published in Utility Dive, as Professor Welton was noting, I think there's many channels, both through the trade press and other types of communications in which RTOs do feel public pressure when they take an action that's widely viewed as unfair. And to the extent that an RTO becomes perceived by FERC or its membership as favoring one membership sector over another, or not being truly independent as they're supposed to be, it makes their job a lot harder. It's harder for them to get filings approved at FERC. The stakeholder processes are more contentious. And I think all of these things do help to encourage RTOs to try to balance things out in the stakeholder process. Of course, voting weights in a sort of sector weighted situation like PJM are what they are, but to the extent that the RTO boards are independent in making some of the key decisions, they are very sensitive to this public pressure. In light of this, I also think it would be really beneficial to explore mechanisms to increase the transparency and accountability to state policymakers. Because again, these RTO, the membership and the boards are very sensitive to perceptions from state policymakers, while not always as responsive as we would like to see. And I actually recommend the New England States Committee on Electricity, or NESCO, published a report, I think it was last year, called Advancing the Vision. And it makes a couple of really interesting governance recommendations about requiring the IS New England board to sort of state its reasons for rejecting the position advanced by a majority of NESCO state members, and otherwise just sort of increasing the transparency and accountability around actions that the board takes that are contrary to state interests. So obviously this is far short of something like giving the state a veto right, but I think it reflects that even some sort of incremental improvements on transparency can really help to make it harder for RTOs to outright reject really well-considered positions of their state members.
Casey, this is all so awesome, but we're running out of time. I want to make sure everyone gets a chance.
Yep. Yeah, my bad. I'll just leave it this, the last bullet is the last thing I'm going to say, which is just that I also think states should explore what may be within their direct authority to improve sort of funding and capabilities of consumer advocates, environmental agencies that are advocating before the RTOs, to try to help shift that balance as well. So it's not only things that FERC or the RTOs could do to level the playing field, but things that the states themselves could do. So apologies for going over. I'm really excited.
No, it's all, I mean, so much great information. Okay. I wish these panels were a little bit longer, actually. So let's turn now to our last but definitely not least commenter, Rebecca. And remind you questions.
So thanks so much. It's so good to see everyone. And I have to say, I too will give a plug for the law review articles, because I too wait for them and read them, and a plug for those congressional hearings, which I think I actually was part of. And it distresses me a little, because I feel like the same arguments I was making 5 years ago, I might be making today, which is a little discouraging. But, you know, I'm here, I think, to talk about consumers, and particularly about consumer advocates. And I think most people know that most states have consumer advocates that are particularly designated to represent customers at public utility commissions. And also, most of them have the authority to also represent customers at it like places like the RTO and FERC. And, you know, as Professor Welton notes, FERC has recognized that, you know, that what happens at RTOs is important for customers, and specifically has talked about the need to give voice to the people and the businesses who ultimately pay for electricity. You know, I think that RTOs right now, I think more than ever, as you guys have mentioned, are setting rules that really impact our clean energy future. They decide, as we've talked about, who in the wholesale electricity markets who gets to participate in those markets. They decide things that directly impact utilities bills. So, but I will tell you, as somebody who has appeared at our ISO New England and RTOs before, there right now is not a meaningful opportunity for customer participation in decision making, nor is there the necessary transparency to democratize access. It's just not, it's not there. In New England, I can give you a little bit of example. We have two sort of main avenues that people think are for customer participation. And the first one is what we call the Consumer Liaison Group. And I've had the honor of being the head of that group for a very long time. But I will tell you what it is and what it isn't. And what it is primarily an educational forum for customers to come to meetings and hear from ISO New England and hear from the high-level officials at ISO New England and have an opportunity to learn about what's going on there and ask questions. But it does not serve as any kind of decision-making body or influence on ISO's decision-making. And if you want to actually have some kind of decision-making authority, you have to join the stakeholder process, which means you have to become a member of the stakeholder process, which means you need to pay. And it means that you're going to, if you really want to be a real participant, as Professor Weldon noted, there are hundreds of meetings a year, hundreds. And between the subcommittees and the committees and the participant committee, you know, it's a process that is complicated and expensive and time consuming. And I think if you're a regular person, you're not doing that. And if you're a consumer advocate like we are, my office devotes, I'm trying to think, we devote a lot of people. We have a lawyer and an analyst who work full-time on RTO matters. And we have 2 lawyers who spend time on FERC. And we have 2 more lawyers who help with the consumer liaison group. But most states don't, consumer advocates, they just can't afford to devote that kind of resources necessary to monitor or evaluate or particularly influence the RTO process. And absent that full participation, it's very difficult to even obtain information about what's going on there. As you mentioned earlier, Casey, at ISO New England, the board meetings are not open to the public. You can't get copies of the minutes of those meetings. I mean, it is a very insular thing. So what do we do about it? I'll just name a couple of suggestions that that we've thought of over the year. Yeah, we could open Order 719 again. We could. And I think it would be clear that whatever mechanisms we put in place back when we did Order 719, I mean, the Consumer Liaison Group in New England was the result of Order 719. But what we have found is that there is not meaningful participation by the people who ultimately use electricity or consumer advocates. Second, and this has been my rallying cry for a long time, so I can't forget it, which is I think that if we establish some kind of stable funding mechanism that enables consumer advocates to fully participate in the RTO process, in the stakeholder process, I think that that would be helpful. There is one example of that that's in PJM, and it's called the Consumer Advocates of the PJM States, CAPS, and they actively help state consumer advocates participate in the stakeholder process, and they're funded through a small part of the FERC tariff. And I think if we had one in New England, it would be like a penny on customers' bills to fund something like that, very small. The other thing that I think is important is that we haven't talked about today is that ISOs and RTOs should be required to consider costs in their decision making and provide cost impact analysis on major proposals and the reasonable alternatives offered by others. And if that analysis was performed early in the process, which it very rarely is, that would increase transparency and provide consumers with access to the cost information that's the most relevant to them. In our state, transmission and generation accounts for 60% of a customer's bill. That's a lot of the bill, and cost considerations are one way that a customer's cost can be thought about in the decision-making process. I can tell you, I never hear anyone talk about how much this is going to affect somebody's bill. I mean, in an RTO, it's just not what people think about. I think I mentioned earlier we could increase communication between RTO board and consumers. One of the ways that we have been advocating for, and I think we have been somewhat successful, is to have at least one member of the board have experience in consumer issues, and or have a board member who is designated as sort of the consumer liaison board member, liaison. So the last thing I want to do is a pitch to all of us, which is that we all also need to be educators. If we're going to ask the public to get on board with a lot of new transmission and renewable build out, and we're going to need their input, and we're going to need the support not just of the traditional stakeholders. We're going to need a broader public buy-in, including grassroots organizations, academics, elected officials, all those. Everyone is going to have to be informed and be an active public on these matters, because otherwise we're not going to get anything built. And I think consumer advocates like my office can play a big role in that. A couple of years ago, we launched an educational campaign specifically about ISO New England, and to sort of enhance knowledge in the state about what it is and why it matters. And we released 2 videos that we put on Facebook and Twitter, basically explaining the issues for people who aren't steeped in this stuff. And I was told when we were doing the videos, it has to be that a 4th grader could understand it. And that's what we did. And we had a lot of people watch it. And what we did was we followed that up with a day-long teach-in that was attended by about 300 people that talked about people in my office. Each person got an assignment and about ISO New England, and they taught about it. It's just too important what's going on in those RTOs to leave to a group of industry insiders. We really do need to level the playing field by providing consumer advocates with the tools that they need to meaningfully participate, and to bring in a broader group of voices. That's all I have.
Is that it?
That's
Great.
it.
Great. I have some follow-up questions on that as well, but I want to give Shelley a chance just to respond to the comments that she's heard, maybe take 5 minutes, and then we'll take a couple of questions and wrap up.
That sounds great. Thank you all so much for engaging so helpfully with the project. It really means a lot to me. It's like very energizing for going forward with this kind of work to hear that it's kind of making the rounds. Like I think often that I'm writing into a black void, and so this is like the best thing that could happen to me. So I really, really appreciate it. I just jotted down a few things that I thought might be like interesting places to go with this. One, I'll say I really do, like, I fully appreciate the points that RTOs are better than non-RTOs in terms of a space in which to hash out these challenges. I guess part of why I was moved to do this project, though, is that, like, I feel like that is offered as a defense a lot of times for RTOs. And, like, sure, you could say we're doing better than the South, but, like, that's not much of a defense, right? Like, that's a very sort of low bar. And so I guess part of what I want to do is really push RTOs to be the best version of themselves, in no small part because I do think if we want to get all these regions on board with RTOs, the governance questions are actually huge here, right? Like, the challenge of making a bigger Western RTO has been dominated by governance concerns. The Southeastern proposal anemic though it is like the South's version of doing RTO governance that they can stomach, right? Like, I do think governance issues are going to be front and center to getting broader buy-in to markets as a solution. So, you know, I think this is, I really appreciate sort of like the nuanced conversation that we're diving into about how exactly to do that. Tom, I think you're right. I really would like Congress to do this too. I think the CHARGE Act is interesting. The question that I have about CHARGE that I would love to hear your thoughts on. So I'm also, contemporaneously with this project, I've been doing a project on the South and why they didn't go into the RTO model and sort of the story behind that. The key thing that the Southern states all did was they formed essentially an advisory committee to study the problem. And that's where the problem went to die. So I guess my question with the advisory committee is, do you really think it has the teeth that it needs to do what we need to do? Or is it like really sending the problem to die? And, you know, then one other question for the broader group is, I have really wrestled with the question of whether or not FERC should just use its authority to say it has the power to require RTO membership and do it. If you made RTOs mandatory and then you did RTO reform, utilities couldn't walk anymore. Now, I know that this is like both politically and legally explosive, but I wonder what your thoughts are about it if we can't get it through Congress. And then Casey, I really appreciated your points about sort of like soft power in RTOs. I think as an academic, especially, it's been a long time since I was on the inside of RTO stakeholder processes, and I don't see the soft power at work as much. And so as I've gone through this project, I've had a lot of interesting conversations about how the power is greater than it would look like if you're looking at overarching frameworks. I guess the one thing that I would say is that, you know, I think it's imperfectly theorized, but there is a clear relationship between hard power and soft power. Like, the more hard power you have, the more soft power you get to push solutions. And so, like, I don't want to be insensitive to the ways in which this process can move within its bounds, but I also think moving the bounds changes the relationship of sort of like how soft power can work in the system too. So I'm curious what your thoughts are about that. Okay, I think that's about it for now. Let's leave it there.
I think some of this dialogue may have to happen offline after the panel discussion, but Tom or well, any of you, do you want to jump in response real quick to Shelley, and then we'll go to a question from Joe?
Yeah, I can be super fast. Number one, RTO mandate has risen again in the Clean Future Act. There was a provision, and some of that has been informed by the committee's history. You know, Energy and Commerce, as I said, had a lot more kind of push. It obviously did not go anywhere, neither did that piece of legislation. But I think there are several in Congress who think that that's the only way to really kind of push the envelope on this. It is a hard, explosive topic to address, but it's out there still. The other piece on the advisory committee, I think, would be, as a standalone item, I concur that it's not necessarily a good, it's not going to solve all the world's problems. I think the idea is to help take this topic out, elevate the role and the complexity of the problem, bring more attention to it, and couple that with actual next steps that would be enforceable. So that would have to be, unlike just a scapegoat, this would have to be coupled with something else. And this is where the pieces of that Markey bill will ultimately get. The idea is to break some of those pieces up, find more bipartisan support, and then move some of that as standalone pieces. So there's some more in the works behind the scenes on that.
Can I just throw in one quick thing on the other issue about the soft power? I actually have real concerns about the RTO's board and staff acting as policymakers rather than regulators or whatever they really are. Utilities, I guess, is what they are legally. But there's a lot of, I think Casey's right, they care a lot about what people think. And they come up with their ideas and then they're out pitching them. They are talking to reporters, they are at conferences, and they are pitching their ideas. And even if the stakeholder process isn't necessarily along the same lines, and they do go to FERC before their filings, and they talk to FERC about their filings, and FERC gives them a lot of deference. So I worry about that.
Yeah, I wanted to add on the RTO membership mandatory versus voluntary thing that there are states that have mandates for their transmissioners to be members of RTOs, right? Ohio and Virginia come to mind. And most of those were put in place sort of during restructuring, right? And I think that would be an interesting thing for states to look at going forward. And it pains me to say that as somebody who has more recently advocated for states to leave RTOs or to have their transmissioners leave RTOs because of things like these capacity market rules that are so adverse to state interests. So I would say, I would encourage states to explore that as a sort of conditional requirement of something with sort of continued oversight as opposed to a one-time, you must be a member. But I think states can really change that balance of power. And that might be helpful to pursue. So, and on the soft power issue, yeah, I don't want to overstate kind of what can be achieved simply through, well-informed and resourced consumer advocates helping to shape the agenda or get media attention, right? Like that's no substitute in the end for sort of voting power or, some ability to directly influence Section 205 rights. But I think that in the meantime, it can, by expanding the capability and drawing more attention to the issues, it could make it easier to get to that step of getting Congress to act on it, because you've sort of demonstrated how important these things are and how much more effective and effectively those processes operate when consumer views are incorporated at the beginning instead of just having to raise objections at the end. So I suggest it as like maybe a step that will help us to get to deeper reforms as opposed to an end in itself. So. Yeah.
Thank you all. Joe, do you want to ask the panel a question?
Sure, yeah, this would be primarily, I guess, for Professor Welton, but then anyone else who wants to jump in. But the article discusses multiple pathways to better grid governance, including paring back RTO authority, increasing regulatory oversight, better policing, sectoral corporate power, and considering a public option. Of these potential solutions, what's the most feasible in the current climate and could provide the most immediate benefit of reforming the electricity sector?
Yeah, Joe, I really appreciate that question because I think we have focused almost exclusively on option 2, right, which is like oversight mechanisms for RTOs, and very little on the other options, which I think probably is an answer to your question in and of itself that we've all sort of honed in there. But I'll just say, look, I do think one of the things that came up when states were particularly upset with the Eastern RTOs and were threatening exit was maybe you don't do a full exit, maybe you do a partial exit and sort of claw back some of the authority that RTO has taken, but you actually really want, most notably authority over resource adequacy, or like what resources should we be building in the future and how do we decide what resources those are. I don't think that's a totally implausible pathway to go down going forward, but I think it's probably less likely than sort of just playing in the land of reform. I will, though, just put a plug for thinking more about sectoral consolidation as we think about these issues, right? Like, I think that these topics aren't talked about enough together, but it's so striking to me that in the 1990s, at the exact same time that Congress was like, hey, look, we can deregulate this sector because look, competition, right? Competition's going to solve our problems. You'll have, the industry checking the industry. We've got generators that are going to be separate from utilities. And so look, like, let's use competition to drive low prices in this sector. That's happening on the one hand. And on the other hand, they're lifting the prohibitions on utility mergers that had been in place for most of the 20th century. And so you see massive consolidations happening. So like the theory of what's supposed to be checking us today, competition, has actually evaporated at the same time. And so like maybe FERC should be going back and thinking about its merger policy. Maybe Congress should also be thinking, and I think Congress actually has some appetite right now for thinking about the woes of massive consolidation that have happened under deregulation. And like, I think that that is another piece of the puzzle that is underexplored but potentially important.
I want to get to one audience question and then wrap up. And this builds on Rebecca's comments, I think, and something I think is a real challenge is what do you think should be done to help the public become more aware of how critical grid governance is in order to help create the change you're envisioning? I mean, this stuff is hard to understand, even for people who work in this area, right? So Rebecca, you offered a few ideas of things you guys are doing. If there's anything you want to add, great. And would love anyone else's perspective, and maybe like in 30 seconds each, so we can wrap up on time.
I'll just say the video that the Massachusetts Attorney General's office put together and that teach-in were amazing, and I forward them to people all the time as like a quick explainer. So thank you so much for doing that. I think better resourced consumer advocates and other sort of state entities, they can not only engage in the stakeholder process more effectively, but then they can be those messengers to the public. Most consumer advocate offices have like one person covering all these meetings and probably some state rate cases too. They don't have any time left to serve as that kind of public liaison role. And so I would say that's the one thing, is better resourcing all of those offices so they can help to take that message to the public.
Tom, do you have any thoughts?
Sorry, go ahead, Tom.
No, I concur. Go ahead. Go ahead. I don't really have anything other than like communicate, active customers, the enlightened climate conscious consumer. If you can sort of mirror the opportunity between the retail and wholesale side, I think there's one way to get them to care a little more. So that's my big picture observation.
Rebecca, did you have one other thing you want to say?
No, that's right.
Hey, I'll throw one more thing out there that I think everybody should be paying attention to going forward, which is that in addition to everything else going on at FERC, they're right now charged with creating this Office of Public Participation. It is a weird experiment. They've been told by Congress they have to do it, but the idea is to do exactly this, exactly what Linda's suggesting, is figure out a way to engage publics that have not presently been engaging at FERC. It is going to be a huge lift. I don't think they've figured out exactly what it looks like yet, but I think it's going to be a really interesting experiment in how you do this.
I wonder too whether if we're really thinking about democratizing the energy system, whether we need to think a little more broadly about what's truly in consumers' interests. And this is going to challenge everybody, because it's a really nice thing to be able to say is decarbonization should not proceed at the expense of customers. And I know, Casey, you said that that's sort of a fundamental point, and I see that everywhere. But what we saw at the last panel is something we're seeing much more broadly in society, which is that it's in shareholders' interest to get a little less return in order to avoid catastrophic climate change. So I wonder, as they build a public office within FERC for public participation, is that going to be a good thing or a bad thing? And that in part depends on whether we help shape the way we think about what's truly in people's long-term interest. And it's not what it was 30 years ago, when paying less for power is a good thing necessarily. If that happens and it creates 500 generations of elevated sea levels that will most seriously affect those who are most disadvantaged, that's not in customers' interest. So I'm interested in whether part of what needs to be done here is not just simple access to the system, but a reconceptualization of what we really mean by the democratic interest here of the population we're serving.
And on that provocative note, it's going to be a comment, not a question, because unfortunately we are out of time. And we do have a third-year law student, Connor Kreidel, who's just going to wrap things up for us today. This has been a fantastic discussion. All of these panels have been, I think, just great today. Thank you so very much for participating, for the, the sophisticated level of discussion. And Connor, wrap us up.
Yeah, echoing what Professor Bregan said, thank you guys so much. That was a really engaging and interesting panel, and I know I learned a lot, so I'm sure everyone had a really good time. As Professor Bregan said, I'm Connor Kreidel. I'm a 3L here at Vanderbilt Law School. I'm also the executive editor of ELPAR. I would like to start today by congratulating the authors selected for this year's ELPAR publication. We sort through hundreds of articles, and the three that we discussed today are the ones that stood out to us most as proposing the most feasible, creative, impact, and persuasive policy proposals. So thank you all for your very important work, and congratulations. I would also like to thank all of the panelists. We selected these articles because we don't want them stuck in an academic vacuum. Your efforts made this possible, and we are really grateful for your voices and for your time. Thank you also to the members of ELPAR who coordinated this event, especially Catherine Denny, our symposium editor. We couldn't have done it without you, Catherine, so thank you so much. I would also be remiss if I did not thank Heather Luedke, Research Associate at ELI, and Victoria Dorward, Academic and Educational Support Program Coordinator here at Vanderbilt Law School. Each have been absolutely integral over the past year, and I know I am not speaking for just myself, but we would have gotten lost many times without their help. Most importantly, though, I would like to thank Professors Bregan and Vandenberg. They're our guides and our fearless leaders, and none of this would be possible without your support, your guidance, your knowledge, and especially your passion. We have learned so much from you both and have all been given an amazing experience unlike anything else in law school, so thank you both so much. Lastly, I would like to thank everyone who attended today's conference. I know that being glued to your computer screen can be exhausting even after 2 years of practice, so thank you to anyone who joined us all day. If you would like to access any of this recording, it will be available on the ELI website within the next few weeks. The articles and their related comments will also be available in August on the ELI website, as well as in the August edition of ELI's Environmental Law Reporter. And thank you all so much. I know I had a great time, and I hope you all did too.
Thanks again, everyone.